Ms. Staton, do you have a lawyer here? And Mr. Pribble wasn't planning on being here today for anything. Rimley? Yeah, state, please set our record for Jessica Staton.
Thank you, Your Honor. This is State of Indiana versus Jessica Staton. Cause numbers
How about Mr. Pink?
are 64D01 2603F6 3164, 64D01 2209F6 7597. Ms. Staton appears in court in person without counsel. State of Indiana by Gary Gurman.
Let me just check something here.
Good morning.
I don't see that Ms. Rimley ever appeared in the case. I can't very well have her show cause for failing to appear on a case she's not involved with formally. Mr. Pribble's appearance is in, but it would have been withdrawn. Yeah, it was withdrawn back in January.
Well, I'm gonna call her. I've already given her over like $1,000. Like
Yeah.
every couple of weeks we send her like 125.
She never appeared in your case, so
Yeah.
you have to do whatever you need to do there. But at the same time, I don't have any resolution. Have you dropped her for a drug screen lately?
Yeah, and the only thing that came up in it was her methadone, which she is prescribed.
Sure.
And I go to IOP at Porter Stark 3 days a week. They just tested me yesterday.
Okay. You're working with Porter Stark on the
Yeah.
methadone program?
And I'm going to IOP 3 days a week for 3 hours at a time. So
I'll set a final hearing. Do you plan to hire Ms. Rimley?
I wish that I didn't now, but I already given her money. So I think I'm gonna call her and see if, because I don't have money to hire a different attorney. I already given her money. You know?
Well, I mean, you've got a couple options there. I can't give you any legal advice about what to do with relation to any contractual relationship you might have with a lawyer. You might want to talk to another lawyer, see what you can
Right.
find out from them. But I'm happy to set this over until August 28th
Okay.
for a final hearing on the Revo. And if you don't have counsel, we'll handle it without counsel. I'll give you a deadline of August 14th to hire counsel
Okay.
or figure out what's going on with an attorney.
This is it's like 24 classes. It's like 8 weeks. So maybe you should do it till after that. So do you know what I'm saying?
Yeah, when's your IOP done?
Not for a long time. I've only did like six or seven classes, and it's 3 a week. And it's
Yeah, I'm happy
24.
to keep it on the calendar though. Yeah, I just need you to hire somebody within a couple of weeks or come back and ask me for PD or whatever you plan to do.
Okay.
Okay?
All right.
Yeah, Mr. Prosecutor?
Yeah, thank you, Judge. Just for my clarification, I show an entry of appearance by Ms. Rumley in F67597, but it goes back to 25.
When did you see she appeared?
Let's see, I think.
That was for the first Revo.
Looks like, I'm sorry, December 3rd of 2025 are my notes. That's in, as I said, short cause, 76,
I do have her appearance.
7597. And I know I have spoken with Mr. Preble in 3164 because there's a proposed plea agreement in my file.
And that was post-conviction. Thank you for finding that. Mr. Pribble appeared after that, though.
In the probation revocation case as well?
Yeah.
I wonder if he filed his appearance in the wrong cause number.
Yeah, I don't know. He withdrew, though, like 2 days later. That's why he withdrew. Let me see my orders. And she appeared, Ms. Rimley appeared in March and April, twice, May 1st, 7th, June 5th, and she's failed to appear. And we sent an order to her on June 26th. I mean, that'd be pretty awkward. Send a bench warrant out for her. Okay. Well, I have certain obligations under our judicial canons and ethical code that I have to take related to this matter for Ms. Rimley. I think the idea of a bench warrant is probably inappropriate for counsel at this stage. But I will, in this order, again, order her to show cause while she failed to appear on July 31st and then at today's hearing, on today's hearing and on June 26th. And I'll take what actions are required of me under our disciplinary code. Ms. Staton, I will see you back as we scheduled on August 28th, 10 a.m. or 9 a.m. Did I put 9?
Whatever you want.
Did I give you a blue sheet? Oh, what's it say?
I'll remember. I don't need one.
Let's do 10.
Okay. I'll remember. I don't need a sheet.
What's
I
that?
don't need a paper.
Okay, so you see what happens. This is actually kind of instructive. The other day, we had a bunch of attorneys hired by some government or quasi-government organization to be public defenders, and they were on strike, which I find insane. This gives you the difference. We've got somebody who's not on strike. It's a private attorney. They took money from a client, and they've missed 2 consecutive court appearances. We've got a rule to show cause and a referral on an ethics violation. That's what happens to normal big boy attorneys. If you don't have some, government crap in the way. That's what happens if you're in private practice and you screw up. You're held accountable.
I'll remember.
Oh, we'll give you one just to be safe.
Okay.
Yeah. It's our practice, so we would always like to say that we followed our practices. Thank you. You should always cover your midriff in court too, please. Your midriff, your back, your lower back's exposed. That's all right. I just didn't notice till you walked away. Chrissy Kinney, state, would you please set a record?
Thank you.
What's your name?
Sexon Susico.
Hi, Ms. Sukuso. This is Judge Fabietti. The prosecutor and public defender are both here. They're here on both your complaints.
Sex on Susico. I don't know what it is, but that's all I heard.
2026.
I can't hear you. I have a little hard of hearing.
All right. Well, you have 2 complaints here. They both come out of Cherry Hill.
Your Honor, can you tell me who you are and what
I'm
court?
Judge Fabietti. How are you?
Excuse
Your
me?
Honor,
Yes.
I think we just need to have a little quick sidebar.
Okay.
What court is this?
It's Camden Superior Court.
Do we put her in the waiting room?
Yes, please.
Superior Court?
No, I mean,
One-
sidebar with the judge. I apologize, with the judge.
I don't have a complaint.
One moment, ma'am. 1 second.
I already like Judge Fabietti. She's like, I'm Judge Fabietti. How are you? Fully realizing we're dealing with a problem already.
Did you want me to put you guys in the breakout room as well?
Yes,
Or-
please. Thank you.
Okay, no problem.
We're back.
Isn't very hard. Unless you make up stuff.
Hi, ma'am. How are you? This is Judge Fabietti.
That just, by the way, just incidentally, Susudio is the worst song ever written in the English language. It's horrible. It needs to be stopped. It's absolutely terrible.
Again. How are you?
Since I'd like to make a request. Who is everybody?
Well, I'm here, and your lawyer's here. Nancy's your lawyer, and Geraldine's the prosecutor, and everybody else works for the pretrial.
Are you doing video? Who's recording this?
The state, the court is recording it.
Now, I'd like to know what level hearing this is. Is this an arraignment if we're in Superior Court?
No, actually, actually that's a great question. It's not an arraignment. It's what's called a first appearance.
Pumpkins were fantastic. It was a regular Gen X celebration over there.
And my job today is just tell you what your charges are and tell you whether or not you're released. So I'm going to tell you that you're released on level 3. You're released today on these charges.
In our conversation, I don't need a public defender.
Well, she did all the work when she talked to the prosecutor to arrange that release. So you're released on these charges.
Who is the judge here?
I'm the judge, Carol Fabietti.
Well, there's a Geraldine Z down in the place of the judge down here.
Oh, there really? That's funny. Look at that, Geraldine.
I was promoted.
She's the prosecutor.
I think I'm entitled to know who I'm being presented to. Who are you?
Well, I'm the judge. I'm Judge Harold Fabietti.
Your Honor, like I said, we're in Superior Court. At what level? Is this since this is my first hearing?
She hasn't made any secrets about this, you nasty bee. She introduced herself despite your rudeness, seeing that you were not functioning well. And she's been nice ever since. Stop it.
Is this an arraignment?
No, it's just a first appearance to tell you what your charges are and to tell you whether or not you're going to stay or go home. And then on this level, they're releasing you.
Your Honor, there is no such hearing as far as I know. The first hearing where you are advised of charges and plead is called an arraignment everywhere in the country.
It is, but you know what?
I said, I demand to be released. That's it.
Well, you are going home on these charges. And
the charges, as the so-called public defender told me, belong in family court. They're protective orders.
Well, it's interesting you should say that. And it's interesting you should say that because one of the charges.
Family court.
Your Honor, would you let me put her on mute?
A judge are you? What happened to Judge Harvey?
Judge Harvey. I don't know Judge
Superior Court judge.
Oh, these charges are going to family court, and you're going to have a family court date in September. You're right about that.
Oh, like I said, you send me a summons. You release me today. Send me a summons, and I will see you in September if you are family court. Are you family court?
No, I'm a municipal court
What
judge.
are you?
Municipal.
Well, then I have nothing to say to you.
All right. Well, what's going to happen is you're released on these charges. Because Cherry Hill's going to wait and see you on Tuesday for you. Apparently, you have some other charges in Cherry Hill.
Excuse me? Cherry Hill's going to see me on what charges?
Look, one of the charges, if I remember correctly, was a harassment charge.
Like I said, I was told this was Superior Court. The feed got cut off, and now I'm in municipal court?
No. You just asked me a question. I was answering it. That's all.
Well, you just said this is municipal court. But I'm being released today.
The municipal court.
Judge, did you say I'm being released today? What has to happen for me to be released?
The paperwork's going to come over that says that you're being released on level 3, and you can't have any contact with Kurt Braddock, 106 West Riding Road.
You mean with squatters who don't have a deed, who don't belong to don't own the home? Thank you, ma'am.
Well, that's what they're telling
I'm
me.
released. How long will it take?
Ma'am, the quicker the judge can get through, the quicker you can leave. But you gotta let her finish.
Today is I'm released.
Ma'am, let her finish so you can leave.
Until on Tuesday. I'm ready.
Okay, let her finish. She has to put everything on the record, but you have to stop talking so she can finish.
And when you would get released, you're going to report to pretrial services.
I can't hear you because they're talking out there. Hey guys, could you cool it? Excuse me 1 minute.
Oh my God. She's saying other people are being loud. I can't even take it. All right. I got a question for the chat. Has this woman ever been married? Like now or at any time in her life? Did some guy marry her at some point? I gotta know.
You're interrupting. I can barely hear. Could you go talk someplace else?
Now, in these charges, ma'am, you're going to report to pretrial services once a week when you get out. And no more new arrests.
You mean you're putting me on probation?
No.
Well, then I'm not reporting anywhere.
Well, pretrial is what you do instead of posting bail.
Like I said, your municipal court, these are misdemeanor charges. I shouldn't be here in the first place. So if I'm being released, then I don't have bail.
All right. Well, it's in lieu of bail. You report to pretrial services instead of bail.
Like I said, just tell me what it takes to get out of here.
Well, you're being released on these charges. You're going to get paperwork today that says you're released on these charges.
At what time? Because these guards are not exactly kind to.
Literally, to get out of there, she has to do the one thing she can't, which is to shut her hole. I haven't seen this. I'm not sure she makes it.
Open up the doors. The last time I was here, 74 days. And they walked me right out the front door with the guards screaming and yelling.
Well, I can't control that part.
So, like I said, my concern is I appreciate very much the release, but I'd like to know what it will ensure that it happens today on your orders, Your Honor.
On these charges, yes, it'll happen. So you'll get paperwork today. I don't know what time. Maybe after dinner.
All right, thank you.
Thank you. Thanks, ma'am. See you later.
Have a nice day.
Take care of yourselves.
And Kuchner, you and I are finished. Really? Thank you.
Yeah, it's tough to be an Andrew in this chat. It really is.
I did notice that plea paperwork had been filed. Just look at this real quick. All right. And before we go any further, I see this is a VRA case. Do we have compliance?
Actually, Your Honor, I believe these were co-defendants. So it doesn't fall under the VRA, Your Honor.
Okay.
That's correct.
Great. Thank you for that clarification. All right. So am I correct in understanding you've reached a plea agreement in this case?
That is correct, Your Honor.
All right. And this is domestic violence. Is a stipulation? Yeah, it's domestic violence. I have it. I printed it out already. Thanks. Okay. All right. Based on this plea paperwork, it looks as if Ms. Hoyler will be, the plea is to criminal mischief, $300 to $1,000, which is a class 2 misdemeanor. And that this is a crime of domestic violence, which would require a domestic violence evaluation and compliance with that treatment. Is this your understanding of the plea, Ms. Hoyler?
Yes.
Okay. Is this how you'd like to proceed in the case today?
Yes.
And are you being coerced or forced into entering in this plea?
No.
Is it voluntary on your part?
Yes.
Is there anything, are you currently under the influence of any drugs or alcohol or any substance that might impair your ability to make a decision or think clearly this afternoon?
No.
Okay. And you have Mr. Pritchard as your attorney. Have you discussed your legal rights with him?
Yes.
And do you understand those rights?
Yes.
And do you understand that by entering into this plea, you waive most of those rights?
Yes.
And did you discuss with Mr. Pritchard the charges in this case and the potential penalties associated with the plea?
Yes.
Okay. So you understand those possible penalties?
Like financial penalties or?
Yeah, just what the court could impose as far as fines or jail time, just the potential penalties that are associated. If you don't recall, I can go over them quickly.
No, we went over everything thoroughly. I just wasn't clear for a second, but yes.
Okay. So you always also have the right to appear here in person for a disposition and sentencing. Would you like today to proceed by WebEx?
Yes.
Okay. And because you're on WebEx, we just need some verification on a few things for the record. Would you please state your full name and your date of birth?
Christine Hoyler, 7/31/87.
And are you the defendant charged in this case?
Yeah, we both were. Yes.
Okay. All right. And are you satisfied with your attorney's representation?
Yes.
Do you have any questions for Mr. Pritchard, or would you like to discuss anything with him before we move forward with your plea?
No, we discussed everything.
Okay. And to the charge of criminal mischief, how do you plead?
Guilty.
Okay.
Right? Yeah, guilty.
Yeah. Okay. Thank you. And do you have a factual basis for the plea, Mr. Pritchard? Oh, you're muted.
There would be a waiver as to any factual basis.
Okay, thank you. So the court accepts your plea, Ms. Hoyer, as knowing voluntarily and intelligently made with the assistance of your attorney, the factual basis.
No, because I'm telling you the truth. I'm very gay now, and
Basis of which has been waived. Do the people have any statements they'd like to make for sentencing?
Yes, Your Honor. People's understanding this was a fight between two partners. Law enforcement was unable to determine who the initial aggressor was, so both parties were charged. There is footage of Miss Hoyler hitting the co-defendant on the hand, and the co-defendant was charged with assault 3 for shoving Miss Hoyler into a door and throwing her off a chair onto the ground. There was also a mark on her neck. The co-defendant said that Miss Hoyler threatened him with an axe.
Exciting and new.
During this incident, however, there was not enough to charge felony menacing on that particular point. It is understood that Ms. Hoyler grabbed an axe multiple times. However, she used it to damage a chair on the floor. We would just ask that the Rule 11 be followed here.
Okay. And anything for the defense?
Yeah, I'll start with the axe because I think that's a major point of contention. Part of this argument began between the two of them when Miss Hoyler had been chopping wood in the fireplace and frankly was struggling a little bit with chopping the wood, and that.
Oh yeah, this whole axe thing is overblown. She was mid chopping wood, my ass. This woman never chopped wood in her life. It would take her 3 hours to get one stick. Oh my God.
I think there's some advice came from her partner. And again, that's where the argument began, was over her chopping wood. And to be very clear, he told police that when they were having this argument, at some point she was holding the axe. She didn't threaten him with it. She didn't try to swing it at him. And the reason I bring this up is that it's one of the wildest misrepresentations by a police officer that I've ever seen, and that her partner told the police that, again, she was holding the axe and kind of.
Look, people, I grew up in the freaking woods. I have actually chopped wood before with an axe. That requires more upper body strength than this woman has. I guarantee it. I guarantee it.
Was holding it. And then when the police went back to discuss who they were going to charge, the officer turned around and told the other officers that he told police that she threatened, saying she was going to chop his effing toes off. Words that never came out of his mouth on body camera. To the point where I would be even preparing for trial, I went and spliced the two videos of this interaction between the officer and her co-defendant. And then when the officer went and told the police afterwards, because of how extremely different the officer's description of what happened versus what he said. So to say that there was never a threat with an axe, the co-defendant never accused her of threatening with an axe, but she did have the axe.
The lumberjack and he's okay. He sleeps all night and he works all day.
That he hit, I guess she hit him in the hand. I also think that's debatable. He's antagonizing her, videotaping her with a phone, and it looks like she slaps she may have hit his hand, but I think harassment generally comes with the intent to harass, annoy, or alarm. And I think if someone's filming you and you smack the phone out of their hand, I personally don't think you're doing that with the intent to harass, annoy, or alarm. You're doing that with the intent to stopping somebody from harassing you. This case was very close to going to trial. I think she did damage a chair during this argument. So I think ultimately when the offer was a deferred judgment to this charge, criminal mischief wasn't initially charged. So I told her we could go to trial on the harassment charge, but this may get added later. And again, we're not disputing that she damaged a chair during this evening. And so I guess ultimately we're still asking the court to accept the plea agreement, but I guess I struggled with this case because Miss Hoyler was pushed over. Her partner was charged with assault. She was dragged out of the house by her hair when she called for help, and that's when ultimately neighbors called the police. Police found her outside. She had too much to drink. She's not from here. She's from New York at sea level. The altitude got to her a little bit. And I think she was nervous. She was scared. She struggled to articulate what had happened to the police in a coherent manner. They took that as her changing her story.
Oh, we're throwing an altitude change. By the way, this confirms my theory a little more. She's from New York. Oh, yeah. And then she can't handle the altitude and she starts swinging an axe. BS. She was drunk and out of control. She wasn't going to do anything because she can't even lift the damn thing. But her intent was nasty as hell and reckless. Stop trying to minimize it.
Her partner's significantly bigger than her. There's just again, I think this is a fair resolution because the chair was damaged and it's a deferred judgment and it offers her the ability to keep it off of record. And I trust Ms. Hoyler to be successful on that more than well, again, she damaged a chair. So I think this is fair, but I think the characterization by the district attorney is also a little unfair. In that, I believe Ms. Hoyler was more of a victim this night, but is also getting charged because, well, again, the police, couldn't figure out who to charge. So I apologize for rambling. Like as I said, this case was difficult. This case was difficult for me in advising Ms. Hoyler on what to do. I do think this is fair. I know this has been really difficult for her to go through, but I do think this is the right way to end the case.
Okay, thank you. I appreciate those statements. And Ms. Hoyler, you do have the ability, you're welcome to tell me anything you'd like. You certainly don't have to. I know this, I can tell this is a very emotional experience. Certainly your counsel has articulated things well, but if there's anything else you wish to say to the court, you're welcome to do so, but you're not required.
He definitely articulated it perfectly. I was completely misrepresented in that on all of the police cameras when they talked to both my fiance and I, they put those words in our mouths. Yes, we overserved ourselves and we were having a hard time, but the way that the police officer was speaking to me I was so scared and so polite and so worried. He was putting these words in my mouth. And when he came out and said that to both of us that, well, you chop toes off or something, we both, my fiance and I were like, what are you talking about? It's
Ma'am, are you a whore?
never on any camera. That never happened. But anyway, I'm rambling, but I understand they couldn't figure out who the primary.
Now you're going to cry. Where?
Aggressor was, but I do have to say that I definitely was more of a victim in this. And I just appreciate you listening. I'm sorry.
No, that's okay.
Of course, Pumpkin, you're always the victim, even when you're wielding an axe and threatening to cut people's body parts off. You're still the victim, Schnookums.
Appreciate you letting me know and making those statements. I know it's not easy.
I did have one last request. There is going to be a request to waive any fees or fines. My main reason being she was put on testing at the beginning of this case. Because she lives in New York, she had to go through a third party and I believe was paying roughly $80 a test and was doing that, I believe in the beginning, 10 times a month. So I don't have an exact number, but she at this point has spent close to, if not thousands of dollars on pretrial testing, and it's been
You have those receipts. I'm sorry.
No, it's okay. It's been a significant financial burden. So if the court's willing to, whatever fines the court's willing to waive or able to, Ms. Hoyler would appreciate it.
Your Honor, the people don't object to any waiver of fines the court finds appropriate.
Okay. I am going to impose a nominal, just it's not much, a $25 fine. Standard fees and costs and surcharges may apply. Just those are the standard fees and costs that are incorporated with any action. All remaining counts, if any, are dismissed. And I know this is a 24-month supervised probation. There's no monitoring, right? Requested.
Not from the people, Your Honor.
Okay. So it's a 24-month deferred judgment. So it'll end July 30th, 2028. So that's 24 months of supervised probation then. So the standard, you're not going to be on any kind of monitoring, Ms. Hoyler, but
She said, fiance, please tell me this guy got a clue and called this thing off. Please, for the love of God.
it is that you're not to consume alcohol or drugs unless or recreational marijuana. If you have a medical, you can. If you have a medical card, but no, you must, remain law abiding. So no new criminal offenses, payment of all fines and costs, and to comply with the terms and conditions of probation. You'll need to, as part of this, because it is a domestic violence component and there is a domestic violence portion to this charge, that you will need to complete a domestic violence evaluation within 60 days following, and you'll need to follow the recommendations of that evaluation, okay? And so contact probation today, and I'm sure Mr. Pritchard can help you connect with them, but you'll need to get a hold of them. They might be, it's kind of late in the day. They should still be there, but our standard order, I'm going to change this to 24 hours. So, just contact probation within the next 24 hours. You'll need to sign the terms and conditions of probation. They'll go over those with you and have you sign those so you understand. And then that's it. I think as part of the domestic violence evaluation, if there's a class that's required, that needs to get completed within the next 12 months. But obviously no jail. And I think that covers everything. Are we, there are protection orders in here in the case.
They've been modified to allow contact and cohabitation. So I think
that was back in May. Okay. So those are gone. Never mind. Just so for the record, we have that.
Sorry, Your Honor. Are you saying that the protection orders are being dismissed?
Not dismiss. Well, I thought they were so just the standard provisions of not harass.
Yes, Your Honor. That's what the people would ask for, Your Honor, just for the duration of probation.
So for the duration of probation, those will remain, but they're as modified.
Yes, Your Honor, of course.
So the only conditions that remain are that you shall not harass, molest, intimidate, or retaliate against any witness or victim in this case, and you'll not possess or consume alcohol or possess or consume firearms. And that's just for the duration of your deferred judgment and for probation. Anything else that we can accomplish today?
No, Your Honor. Thank you.
One question.
Sure.
Probation, I'll be able to have transferred out here to New York. That's okay.
It's at the discretion of probation, but as long as, probation in New York is willing to supervise you, generally there's no issue.
Okay.
Yeah. And I don't think there's any objection to that.
No objection with the people, Your Honor.
It's more convenient for everyone. So, and especially for you.
Thank you.
You're welcome. Okay, Ms. Hoyler, wish you the best, and hopefully, we won't see you back here.
Yep. Thank you.
All right.
Thank you.
Have a good afternoon.
All right. Court calls 25 CR 1044 concerning Paul Crown. This case comes on for motions hearing. Mr. Crown, the court recently granted the public defender's motion to get off your case because you were supposed to reapply and didn't. That is why you don't have a lawyer here. Are we ready to proceed on the motions hearing?
I believe so, Your Honor. I don't think anything was really filed. I did have a chance to speak with Mr. Crown before court, and I told him that the trial date is still set for August 3rd. I talked to him about his speedy trial rights. He has informed me that at this time he doesn't want to waive those, despite perhaps looking for counsel. I'll let him make a further record on that. I did tell him that as we get closer to trial and as we start subpoenaing witnesses and expending resources, I'll be less inclined to stipulate to a continuance of the jury trial. He understands that. I don't know if he has a further record to make.
All right, Mr. Crown.
Yes, ma'am. It's not that the public defender did tell me that when I was released from jail, that they wouldn't be representing me anymore. And the first thing I did when I got out of jail is I emailed Mr. Sherman with my telephone number and email address. Didn't want him to think I was running away or anything. Assured him that I was going to be here today. And when I saw that it was a motions situation today, I thought since I was here a half hour early, it would be reasonable if I could find out what exactly the motions were that were going to be discussed today, and maybe even get a copy of them. But they told me that that wasn't the policy. And Mr. Sherman said that because I was representing myself now, that he said we wouldn't have motions, but I know that's up to you.
No, if there were motions that were litigious that needed testimony and that type of thing, yes, we would be having a hearing. I don't have anything that's been.
I mean, it's just a fundamental misunderstanding of absolutely everything that's going on. I was sure we wouldn't be having motions, but I guess that's up to you. Yes and no. It's up to the judge to set motions for hearing that are before them. But you didn't file any motions because you know what the hell you're doing. And the state didn't file any motions because you weren't doing anything and they already have the case lined up. So there are no motions for the judge to contemplate.
Filed from your former attorney that requires a hearing, and I believe I've issued orders on all of the motions that were filed. So really, this is a hearing that's a bond return date to make sure everybody understands the posture of the case and that we are proceeding to trial August 3rd. I have a set for a 5-day trial August 3rd, and it looks like you're charged with 2 Class 3 felonies. So it's very serious. Why didn't you reapply?
Ma'am, the particular public defender, actually there were 2 at one point who were on my case.
Yeah.
One of the things, there were several things that really bothered me, but I'll just get to the first thing that I think we can handle today. And I even spoke to Mr. Sherman about it. There's no mystery. From the minute that I was arrested and the minute I got into jail, I believe it was October 24th, I've been asking to see the evidence against me, the discovery that is out there. I was told there was 350 pages. The lady, Miss Malcolm, when I was arrested, she had me sit for 10 weeks in jail, said she wasn't prepared to deal with the case. She didn't know the facts. She had to read 350 pages. It was going to take a long time and so on. And I asked if I could have the 350 pages because I was just sitting in jail. They want, reading some novel that I read when I was 16 years old. I'd rather read the discovery. And she kept saying, yeah, she'd give it to me. And she was going to give me a flash drive. And every time I saw, which was hard to just see her, she never answered the phone, didn't answer the messages. I mean, I had no communication. Plus, I didn't have any money on my phone. You can't put money on your own phone in the jail. I couldn't contact other lawyers. I couldn't.
Skip to the point where you get out of jail.
I'm sorry, ma'am.
That's okay. Hold on one second.
I don't want to be a burden on you.
You're not being a burden, but you need to listen to my question.
Yes, ma'am.
My question is, and this is the only question I need an answer to, why didn't you reapply? I understand maybe perhaps you were not happy with the performance, but now let me tell you, a lawyer on a case like this, no matter how much effort it takes to see them or talk with them, is what you need to defend 2 Class 3 felonies.
No, because I'm telling you the truth. I'm very gay now,
And it sounds to me like you just decided you were going to go on your own. Is that right?
Well, actually, I was going to tell you that I still wanted that the lawyer, Miss Malcolm, finally just refused to give me the discovery. And so therefore, I felt like she wasn't the right lawyer for me. The public defender's office in general did not want me to see that it's, and they just kept trying to bully me into these deals and stuff. And I feel like there might be a lawyer out there that could be appointed that is outside the public defender's office, that's not already involved, that might be available. That's one thing I wanted to discuss with you. And the second thing is there's this other lawyer that I was out on bail for 5 days in King County, Washington, and I was able to use the internet. And I found this guy. I found his name. His name's David Moorhead.
No, that guy was Mitch Kumstein.
Well, we had a little bit of email communication, but then I was arrested on the governor's warrant and I couldn't use the phone. I don't have any money on the phone. I couldn't do anything. So all this time in jail, I was unable to seek counsel and speak to people who could defend me. It's not like I just chose to be an idiot. I've been in jail, ma'am, and I couldn't use the phone.
Well, I show that you posted bond on May 15th.
Yes, ma'am. And the first thing I had to do was get my vehicle out of storage so that I have my clothes and food and a place to sleep. And I immediately came back here after contacting Mr. Sherman, as I said. I just want you to know that being in jail is pretty tough. It's not easy to just think about things like this.
Oh, you love it. Don't even pretend. And look at that. Look at that there. It looks like I summoned the food fairy with my Mitch Kumstein reference.
When you've got to survive out there. I'm a homeless person dealing with life out there. And it's tough. And I do have my mind on this. And I'm not going to mess with you. I'm going to be here when I got to be here.
There's no thought of you messing with me, Mr. Crown. Not a chance, but go on.
And I've spoken to Mr. Sherman in a civil manner. And I just want you to know that I do, I would like to talk to a lawyer, but I'm not sure which lawyer or if a lawyer is available through the court, like an appointment system, or
this is all spoken like a guy who really enjoys being in jail, which is what I think we're dealing with. And I'm not joking.
I can contact this guy. I mean, like Mr. Sherman says, it's pretty close to trial. Otherwise, I'm just going to have to wing it on my own and do the best I can, because the public defender's office, I don't think they really want to defend me. I felt like they were working for the prosecution more than me, and they won't even let me see the evidence against me. They won't let me see what this case is all about. And I think that's a real problem, ma'am. And I'm still waiting to see that. And like, for example, today, if there's going to be a motion hearing, God, is it so bad of me to want to see the motion in advance and see what's going on?
It's not bad of you, but Mr. Crown, this court has you've been out of custody. I've not heard one peep about your issues with the public defender, but let me get to the point, because I'm not going to keep Mr. Sherman waiting here. We are, as I said, the motions that have been filed, the court has ruled on. You can certainly go to the clerk's office, pay to get the motions. I would think Ms. Malcolm would be willing to make you copies of the motions that have been filed in your case. She filed them. So it is your right to have motions. She filed the motions on your behalf, which is her lawyering on your behalf. She filed good motions. They were sensible. The court made rulings on them. And we are proceeding to trial. All the things that you're saying, I understand life is hard. This is your priority. Class 3 felony, up to 12 years in prison, 3 years mandatory parole times 2. That's what you're looking at. So to the extent that this isn't your priority, it should be. You don't like being in jail? I promise you prison is not better.
I'm probably going to die in jail, ma'am. I realize that.
I don't know about all that, but my point is no, the appointed lawyers are the public defender's office. This court deals with the public defenders every day in trials just like yours, and they are as good as it gets. They're as good. I'm very familiar with David Moorhead. If you're going to have a discussion with him, I believe if he was entering into this case, he'd be fine to get up to speed on this case by August. But you would have to get him entering by next week, would be my guess. I'm being harsh with you because you're not doing what you need to do to attend to this case, period. And you don't get to bail because you don't like your lawyer. This is a free lawyer to you, which, believe me, sir, is far better than somebody who has no law school training or any background as a lawyer, period. So when I say free, lawyers are very expensive, extremely expensive. And because of your indigency, you qualify for a lawyer and you let that go because of whatever you thought was in your head about not getting to rediscovery, them not doing what you feel they should do. And that's a choice you made. And now you don't have a lawyer. Do you understand the gravity of the situation that you're in? And I have no reason to continue this trial right now. We're set to go August 3rd.
I have not asked for a continuance, ma'am.
Well, I understand that you didn't ask for it, but it sounds to me like you're going to be trying to get a lawyer. Is that correct?
Well, now that I've discussed it with you, and you know, again, you hear things in jail and all about these appointments and so on. So I thought it was worth it to find out if there was a list of lawyers who can be appointed to these kind of cases.
There is not. There is a list of lawyers that get appointed when the public defender has a conflict. They don't have a conflict. The problem was you didn't do what you were supposed to do. So she got off the case, which is what she is supposed to do. So what you were supposed to do was apply when you got out of custody for the public defender's office, and you didn't do that. Are you?
Okay, I screwed up. This is a really long video. I don't know what to do now. I was trying to do the shorter clips and do this another time, but this is a really long video. Tell me in the chat.
Going to do that? Are you going to reapply so I can get her appointed so you have representation?
Are you ordering me to?
I can't order you to. I cannot order it. It's your right to have representation or not. It's your right to waive representation. So I don't have the ability to order you to do anything. But I can tell you what I'm going to do next is I'm going to advise you about representing yourself. If you don't have a lawyer, I'm going to set the matter for a status conference. I'm going to set it for 2 weeks from now. If you don't have a lawyer at that time, either by applying for the public defender, which you should have done in the first place, or hiring your own attorney, I'm going to find that you've waived your right to counsel. Does that make sense?
Yes, ma'am.
All right. So what I'm telling you, the most important thing in your life at this moment is to apply to the public defender's office. And the reason I say that is because your liberty is at stake. Does that make sense to you?
It does, ma'am.
All right. And so the court is going, I hear what you're saying. I hear your disenchantment with the public defender's office. They don't always agree with some of the things that the people that they represent want to have happen. It might not be the best thing for the case, but I can tell you this, what is best for you is to have an attorney. Does that make sense?
Yes, it does, ma'am.
All right. So is there anything, I'm sorry, Mr. Sherman, is there anything that the people need to do with regard to motions?
No, Your Honor. Just quickly, I will, right after this hearing.
I mean, I'm not even being facetious. This guy appears to be gay. I don't know, but my guess is he's gay. Fine. He reports to the court he's homeless. And I'm not making a joke here. Being thrown in jail for a gay homeless guy is not that big of a punishment. In fact, it's solving all your problems in life. I'm sure you would prefer to be free and have that, but it's not as bad as it is for anybody else. Just saying.
Link up with our discovery people so that Mr. Crown can get pro se discovery. And I also just want to put on the record that I believe that Ms. Malcolm is a phenomenal attorney. And in my dealings with her in this case, she has taken it very seriously. And I thought that she has done a fantastic job. So I just wanted that to be on the record. But I have nothing.
I appreciate that. And I'm sure she would too. And so the other thing too, you should know, Mr. Crown, is that, as I said, the court deals with the public defenders in this division every day. And you may or may not know that in Colorado, the public defenders are a very good defense. All right. And it's not the same anywhere else, or I shouldn't say it's not the same anywhere else, but but they are far and away the most reputable defense attorneys in Colorado.
I'm not saying anything bad about Miss Malcolm whatsoever. I'm just saying that in my case, I had some doubts and the application has some issues on it, which are difficult for me to make a decision on. It's not as easy as you think. And I'm not trying to delay or cause the court any inconvenience. It's a serious decision. And I don't want to disparage Miss Malcolm or the public defender's office. It's just that I'd like to see the evidence against me if I'm allowed. And that's all. If I'm not, and it was her professional decision. She finally decided after many months not to give it to me. And she told me that. She said, in this state, it's my decision whether to give that to you or not, and I'm deciding not to. And I said, yes, ma'am. I didn't argue with people. I just, that particular was one little sticking point.
Okay. Well, I got it. I don't need to hear any more about the story. So what I'm going to do now is advise you about your rights about having an attorney and what can happen if you don't have an attorney in the next 2 weeks, as I've just said earlier. All right. You can sit. You don't need to stand. All right. Do you understand that you have a right to be represented by counsel throughout these proceedings?
Yes, ma'am.
If you can't afford an attorney, the court will appoint one provided free of charge. Do you understand?
I mean, literally, like, it didn't occur to me until I thought it was a guy. I assume it was, but then it sounds like it's a gay guy because it's got a real high voice. And then someone says it's a woman. It could be a woman. I don't know. I don't know. I can merely speculate. It's a lady. I'd say either way, either guy or girl, this person is gay. That's my guess. That's my speculation.
Yes, ma'am.
All right. As I stated earlier, I was looking at your charges, and you are charged with the first count is theft of $100,000 between $1 million. That's a class 3 felony. I want to make sure I'm right. And that carries between 4 and 12 years prison and 3 years mandatory parole. And count 2, you're charged with cybercrime and commission of theft, $100,000 to $1 million. That's also a class 3 felony with the same penalties. So I want to, do you understand the charges against you?
Yes, ma'am.
Do you understand the possible penalties?
You've made it clear.
Do you have any legal training?
Yes.
A little bit.
And when you say a little bit, what does that mean?
Back in the early 90s, I did a little civil litigation.
What do you mean you did a little civil litigation? You represented yourself or?
No, ma'am. I do have a law degree. I was a member of the Florida bar for many years. I'm retired from the Florida bar now. So.
Where did you go to law school?
Nova Southeastern, ma'am.
Okay.
Oh, sweet Jesus. What?
Yes, ma'am.
For how long?
I retired from the bar just a couple of years ago. So, I did my CLE and
Nova's a law school I've heard of, although I'm not familiar with it. But just saying I retired from the bar does not sound like something an attorney would say. I'm not saying she is lying. I'm not. Maybe they got like a law degree but never did anything with it. But that's just not the way a lawyer would. They would say we're retired from practicing law. You wouldn't say I retired from the bar. It's just a dumb thing to say.
kept up that way. But I left the active practice of law back in 1995. I didn't want to do it for a living anymore. But, I did pro bono, and I did come back in the early 2000s and do a few cases I had to do and things like that. But I mean, I wasn't in the active practice of law since 1995, except for did a couple of appellate matters and things like that.
Well, that's far more experience than most defendants that this court sees, but go ahead.
Yes, ma'am. I did a few contracts and things like that. I never did any criminal law. I should have. But I didn't. And I had an opportunity and I let that go like an idiot. But anyway,
well, you have established that you're an idiot. So that doesn't surprise any of us.
That's that. You asked the question. That's the answer.
Okay. Are you under the influence of any drug, medication, or alcohol that would affect your understanding of my advisement today?
No, ma'am.
All right. Do you want to consult with the public defender before you decide if you want to waive counsel?
I'm willing to talk with the public defender for any reason whatsoever. In fact, what you just recommended about talking to Ms. Malcolm about these motions, my understanding was she just did some motions for bond reduction that were denied. That's all she told me about. If there were anything else, I didn't even know about it.
Okay. I'm not talking about that. I'm talking about whether you would like to talk with the public defender and file your application and that type of thing before you decide if you want to waive counsel or not.
I would.
Okay.
I would, and I intend to contact Ms. Malcolm. Absolutely.
Okay.
Yes.
So as you pointed out, criminal law is a complicated area, and an attorney trained in this area could be of great help in preparing and representing your defense. Do you agree?
Yes, ma'am.
All right. Do you want the court to appoint advisory counsel? And I can tell you that I'm not willing to appoint advisory counsel at this point. Advisory counsel is if you qualify, so you'd still have to apply to the public defender's office. That's an individual who is sitting next to you but does nothing during the trial. You would be in charge of all of it. Typically, I ask this question if you're wanting to represent yourself. What I'm hearing from you right now is you want the opportunity to reapply to the public defender's office. Is that right?
The truth is that I haven't made the decision because I haven't spoken to this guy Moorhead again. And I was waiting till today to find out if there were lawyers that could be appointed. And now that you've told me that there aren't, then I have to think about this. And again, I have to, in order to qualify for the public defender, ma'am, I have to qualify under the rules.
I'm aware.
I have to fill out yes, of course you are. I know you are. There's the application. And, I'm not a wealthy man, but, I own a vehicle and stuff like that. I mean, I need to find out if I'm going to qualify.
I agree.
And if I don't, then I have to represent myself or get another lawyer. So I'm not trying to drag heels. I just got back into town a couple of days ago.
I'm going to stop you because I'm in the middle of an advisement.
Yes, ma'am.
And
okay, I'm so confused. Now I was convinced that it's a woman, but Helen DeGeneres here says that she's a man now. Or he. I literally don't know. I don't care. I don't give one whit. I really don't, but it's just going back and forth. It's Pat, for crying out. It's Pat. That's what we're dealing with.
and I just can't take up all the other things right now.
I understand, ma'am.
So you have the right to represent yourself, but by doing so, you take great risk of not properly presenting your case. Do you understand that?
Yes, ma'am.
All right. You have the right to confront witnesses against you and cross-examine them. You have the right to have witnesses you choose compelled to appear and testify on your behalf. You must exercise diligence in pursuing your right to counsel by either making application to the public defender's office or contacting private counsel. What I just told you needs to happen within the next 2 weeks. Do you understand those things?
Yes, ma'am.
All right. Failure to exercise diligence in seeking counsel will at some point constitute a constructive waiver of your right to counsel. And so how do you want to proceed?
Decide what to do, and I'll have to inform you, is the way it sounds to me.
That's correct. Well,
That's the way I'm thinking.
It's more than informing me. So I would suggest, I would highly encourage for you to go to the public defender's office today and apply, because even if you decide you want to hire somebody, you need to have that application in. I'm not giving you very long for them to consider it. That's because I have a trial set August 3rd. We're going to set a status conference on June 17th. Mr. Sherman, can you make that date?
Just looking at my calendar now. You're right. Yes, Your Honor, I can do that.
Okay. So I'm going to set the status conference for June 17th at 8:15. At that time, I'm going to ask you if you've got a lawyer present. If you don't, I'm going to waive your right. I'm going to find that you've waived your right to have a lawyer present, and we're going to proceed with you representing yourself. Do you understand?
Yes, ma'am.
It's very critical. I don't know how many times I need to repeat this, but it's critical that you apply to the public defender's office today, because that's a very short timeline for them to consider the application. Does that make sense?
It does make sense, ma'am.
And then when you talk to Mr. Moorhead, he's very familiar with this court. Let him know about the court date that's set. Let him know that you have a trial set. Let him know what your charges are. It sounds like Mr. Sherman's going to give you the DA's packet of discovery today. Is that right?
And I actually, during that advisement, I just emailed our pro se people or our discovery people, and I CC'd Mr. Crown. So the ball is rolling on that.
All right. So you can even share that with Mr. Moorhead, since you'll have it. And that's going to be the order of the court. Is there anything else that you need to discuss today?
Well, there's just one thing, ma'am, if I these motions that we're going to go on today, Mr. Sherman mentioned that they weren't going to go on today. And
well, there's nothing to go on. As you should remember, you have the right to file motions on any issue. If they're litigious, I would take testimony from individuals that would support the motion, or support whatever the district attorney is trying to do, or whatever you're trying to do. That's not the kind of motions that were filed. I'll tell you what the motions were. Motion for a discovery of exculpatory and impeachment information. That was granted. Motion for discovery of expert witnesses. That was granted under Rule 16. I think those are the only two motions that were filed. That's it. So there's not anything litigious. It's very, very general motions that typically the people comply with, even without the court ordering it, because they have to under Rule 16 of discovery. Does that make sense?
yes, it does, ma'am.
Those are the motions. That's it. So when I tell you there's nothing litigious, that's what I mean. But again, if you want copies of anything in your case, you can simply go down to the clerk's office and ask for them. You'll have to pay for them, but they're there for you to obtain. All right?
Yes, ma'am.
All right. So I hope I've alleviated your issue with regard to motions. These are things that the people have probably already discovered to Ms. Malcolm, but you're entitled to have them, and you should have them.
Ma'am, if I may?
You may.
I would like to file a couple of motions myself. Would that be
The
allowed?
motions deadline is passed, so the only thing that the court would allow you to file is a constitutional motion, and I'm only going to allow that if it's a credible constitutional motion. Motions deadline was set with you present. Your attorney filed the motions that she thought were appropriate to file. None of those were constitutional motions. There's a deadline to file them. She met the deadline. That deadline is passed. So if you have motions, my suggestion is to talk with your attorney. I hope you have one, to see if there's something the court would consider beyond the deadline. Anything else?
Could I ask what the deadline was, ma'am?
Yeah.
These are the sorts of things an attorney, someone who used to be an attorney would have caught. I'm just saying.
Hold on. Mr. Sherman, if you could look too.
It would have been 35 days before
Today's
Your
date.
Honor.
That's right. So motions were due 35 days prior to the motions hearing date. Those were filed timely. And today is the motions hearing.
So if there's a constitutional issue, the motion could still be heard.
It could. But if there was one, my guess is that Ms. Malcolm would have filed it because she was under an order to do so by that timeline. All right?
Yes, ma'am.
All right. So that'll be the order of the court. We'll see you back here on June 17th at 8:15. Did you write that down?
Yes, I did.
The date? All right. All right. And I have some expectations, Mr. Crown.
Yes, ma'am.
And my expectations usually get met. Do you understand?
Yes, ma'am.
All right. We're in recess. Anything further, Mr. Sherman?
No, Your Honor. Thank you.
All right. Apply to the Public Defender's Office.
I got the application, but decided not to submit
Ooh, dogs. All of a sudden, we got a simp dom thing going on here.
it.
Why is that?
There are various reasons, but basically because I experienced 3 different public defenders and had negative experiences each time. And after thinking carefully about it and considering the matter, I decided that the public defender was not going to represent my interests, my best interests, and that I better do it myself as best I can.
All right.
Good thinking, big
You and
dummy.
I talked about this quite a bit the last court hearing, so I'm not going to go back over how much of a risk.
A big part of his consideration was the entertainment over on Law Talk with Mike, apparently.
That is for you to take, even though you're an attorney or former attorney. I feel a little bit better about that, but even a terrible public defender, which doesn't exist in Boulder County, if not the state, would do better. But I've already talked to you about that, and you decided not to hire counsel?
I did consult some counsel, but wasn't able to afford their services.
All right. Then we are set for trial in this matter on August 3rd for 5 days. Oh yeah, okay, I can see why it's set for 5 days. All right, Mr. Sherman, anything?
Your Honor, I spoke to Mr. Crown before Your Honor came out. He informed me of his decision to go pro se. I did tell him, and I wanted to make this record for the court, that I'm just incredibly uncomfortable about this decision. I'm more uncomfortable about, he just got discovery a few days ago. I mean, it's thousands of pages. And he's going to have less than 60 days at this point to review all of that. I did talk to him about waiving speedy, continuing, something I would be open to so he could be prepared for trial. He's not deciding to do that right now, but he told me that if he decides to go that route, he can reach out.
Then get your witnesses together and whack his ass. That's what he's asking for. If he won't waive speedy, what the hell do you want the judge to do?
To me. So we'll just go from there, I guess. But
Cowboy up.
This does obviously just make me uncomfortable.
All right, well, Mr. Crown, let me just let you know some observations I've made with regard to the.
You know what makes me uncomfortable? Grown men overusing the phrase, "this makes me uncomfortable." It makes me want to give somebody the back of the hand. You know what I'm saying?
Situation that you're in, you're not the first, but you are set for trial in less than 2 months, and it's a serious charge. We've gone over the charges and the possible penalties. I would imagine there are many documents given the charge, or one of the charges, if not both of the charges. It would be really unlikely that an attorney who practices this every day would be ready to go to trial on this case if I appointed one today. I understand, you understand your right to have a speedy trial. And at this point, the court has set it within speedy trial, which was August 13th. Well, is August 13th of 2026. It is not uncommon for an attorney to ask the court to continue the trial when they've just gotten discovery. But that would require that you waive your right to have a trial within 6 months. Do you think you're going to be ready to try this case pro se in less than 2 months, not having reviewed the discovery in the case?
Well, that's certainly my goal, Your Honor, and I am working on it, and I did get the discovery, and I've looked through a lot of it. I don't see anything in it that says I have this cryptocurrency. I mean, it might be in there, but I didn't see it, but I'm still looking.
That's not my question.
Yes, ma'am.
Okay, this thing is long, although we've already done a good chunk of it. I meant to do it by itself. That's fine. Here we are. Let's finish it now. But this is multiple court appearances. Zach put it together. I don't know if we get the trial or not. Now I'm all in.
I'm not asking you whether or not you think that the crime can't be proven by the prosecution because you're not seeing in the discovery something that that alleges you did it or something that finds you did it. The prosecution feels they had probable cause and they charged you. What I'm asking is, regardless of what you think the evidence shows, do you believe you will be ready to try a felony case of this magnitude in less than 2 months?
I'll have to do it, ma'am, and I plan to.
All right. You have the right to ask this court to motion the court for a continuance, so you'll be ready. And so you'll have time. There's no shame in that game. It happens all the time. But if you stand there and tell me after I've advised you of how Mr. Sherman has said he's not going to object, which that happens, and you have that opportunity, if you tell me now.
Oh, there's shame in this whole thing. All of it. Shame, shame, shame. Don't make me get out the Judge Stevens clip.
Now that you intend to proceed to trial, that's what we're going to do. I'm giving you the option to have more time, and you should take it. But it's up to you.
Your Honor, I did discuss this with Mr. Sherman, and I am aware that there are these openings, and my...
What do you mean by, I'm sorry, openings? What do you mean?
I mean, an invitation to apply for a continuance and to go forward on that route like you mentioned. And I hear, Your Honor, loud and clear, and I heard you about the public defender, and I hear what you're saying, and you better believe that I respect it. But when I've deeply considered what I really believe and know about this case, I have to do what I think is best for myself because it's my life on the line.
And you think what's best for you is to not take the opportunity to have more time to look through that discovery and prepare your case?
At this moment, yes, ma'am.
Okay.
Yes, Your Honor.
All right. Well, then we'll continue to trial. Mr. Sherman, is there an offer?
Yes, Your Honor, there is.
And you conveyed that to Mr. Crown?
I have.
All right. And is there a timetable upon which that offer will expire?
I would say June 29th, which is our 35-day discovery deadline. After that, we're going to be in trial mode.
Mm-hmm. All right. You heard it. Stay in contact with Mr. Sherman. All right, Mr. Crown?
Yes, Your Honor. Absolutely.
All right. Thank you for your appearance.
And thank you.
You're welcome. We're in recess on that case. I've got an outstanding motion asking for the people to produce telephone call recordings and transcripts and fingerprint evidence that was filed last week, toward the end of the week. 1 second. And let me take a look at it. Have the people had a chance to read that motion?
We have, Your Honor.
All right.
Lee Norwood for the people. Would you like me to substantively respond now?
Hold on 1 second. Let me just take a look. All right. Go ahead.
Yes, Your Honor. First, in regards to the calls with Special Agent Allenson, the people have turned over all calls that we believe exists. We did reach out to Special Agent Allenson on July 14th to see if she was aware of any additional calls. In fact, I forwarded Mr. Crown's response verbatim just so that there was no confusion. She told me she's discovered everything that she's aware of. She said that at some point her phone was having issues, so it was possible that he called, and so it shows as a record on his phone, but she never actually received it, and they never actually made contact with each other. I did discover her email. It was discovered to Mr. Crown on July 20th. I know he is pro se, so the discovery receipts don't work quite the same way they would with an attorney, but I do believe he received it. Next, Your Honor, in regards to the fingerprints, the people have no reason to believe that there is forensic fingerprint evidence. The only reference to fingerprints in this case is what Mr. Crown cited in his motion, this offhanded comment about, would your fingerprints be on Mr. Amari's desk? That's the only comment I'm aware of. I don't believe that any actual fingerprint forensic science was conducted, and so I can't turn over something that doesn't exist.
All right. Thank you. Mr. Crown, anything further then?
Well, Your Honor, at the back of the motion, and I am sorry to have filed the motion because I know that the court doesn't really want any more motions at this time, and
You're entitled to file whatever motions you'd like, Mr. Crown. It's not about whether I want them or not. I can't consider some motions, which we'll talk about in just a moment. So you don't need to apologize.
Oh, okay. Well, great then. Then I won't. I just, I don't want it to step on toes where it's not supposed to be stepped on. And I just point out that, it's not just something I made up or something I dreamed up to cause trouble or delay. The calls existed, and there's a record of them at the back of the motion, which came right from the discovery. The discovery is tremendously voluminous, and getting into it, even just opening some of these files, can take a half an hour just to get in there. But I was able to get in there, and the calls, there was, every call that's made to them is recorded except the ones that I need. And gee, there's a problem with the phone, and it's just like the Korean language thing where, well, gee, I forgot to take a screenshot. And so I just wanted to point out to the court that these are real issues that I didn't make up or dream up.
What's the Korean language thing? The hell is she talking about over there?
I thoroughly and diligently confirmed the existence of these issues and would not bring them to you if I didn't honestly, sincerely, carefully believe that they exist and that they're pertinent. What can I say? If they're not coming, they're not coming. Now, as far as the fingerprints goes, well, great. I mean, like anybody, I don't think there's any fingerprints, but when you read the affidavit, it's an issue, And before I came to you or before I brought it up, I hit those. There are thousands of pages. I hit everything hard to make super, super sure there was nothing in there. And I just want you to know I didn't want to annoy you or anybody. But it's pretty serious. If there are fingerprints, that's serious stuff. And I had to know, now that Ms. Norwood has said that there's no forensic fingerprint, which is, as you can see in the motion, I asked for that as an alternative. Well, that's great. Then that's something I don't need to sweat, because you can believe I'm sweating 1,000 other things, big time. But, so I just want you to know that everything I've done and all the motions that I've filed, I even went and got an audio recording of Your Honor's ruling on the previous motions. And Your Honor said that constitutional motions would be permitted. And so the motion, like for the jurisdictional issue, which I still think is an issue, it wasn't intended to break your order or rudely come across on you. I would never break an order of the court, voluntarily. I've been careful about that. And I just want Your Honor to know that it was all done respectfully and properly with real research. Hours and hours of research in those motions. And they were constitutional issues. There's no doubt about that. Subject matter.
Well, let me ask you,
yes,
Mr. Crown, I don't disagree. I think where the court,
may I sit, member?
Yeah, have a seat.
Come up here.
No, have a seat. Where the court, the court, the last time that we had a hearing, what I'm most concerned about is your ability to be ready for trial. The district attorney said there were thousands of pages of evidence. You're now saying that, and it makes sense because the charges are very serious. You filed motions that the court would take up, and I actually think there's possible merit to them. And I say that like normally, I shouldn't say normally, at times when people proceed pro se, they don't file things that make a whole lot of sense. They don't have the understanding of the law that you certainly have, as is shown in your motions. And I just don't have time to consider
Oh, don't encourage it.
them because we're having trial next week.
There's trial next week. We had to cut off of those motions. Stop talking about it as if it matters. Abide by the Colorado Code of Criminal Procedure and carry on.
I would like to consider them, but I can't do that in the time between the time that you filed them and you didn't. What I'm saying is it's not uncommon for defendants to waive speedy so that you have the time to consider the things that need to be considered and to file the motions that.
Yes, and you've suggested this to Big Dummy 14 times, crossing the line into helping them too much, along with the prosecutor, I might add. But Big Dummy has refused that. So, Big Dummy gets the consequences.
And for the court to consider them. And so I think the issue is the time. And so I'm offering again to allow you to do that so that you actually have time. There's really no reason not to do that. It happens all the time with lawyers. When they don't feel that they've had enough time to consider voluminous discovery and have motions that this court could consider, really consider. Have the time to look into them, hear the testimony from the people, hear your testimony if you have any. Those are things that can happen when we have a case of this magnitude. And these are really, as I explained to you before, these are high-level charges. A felony 3 is no joke. So it's not uncommon, nor is it, I can't imagine being in your spot, but I can imagine being in your spot. Potentially you're digging in because you think by going to trial now, that's going to make a difference. It won't. The only thing it does is make you go to trial within speedy, which you have the right to do, but it doesn't give you time to do what I think you want to do, which is make sure you have a command of the discovery, not just having been through it, but also understanding it and not filing motions in a hurry, but potentially filing motions that could have an outcome beneficial.
You have seen the thought process of this individual in court. You could give them 3 decades with the discovery, and they're not going to be prepared or say anything remotely intelligent. Stop it. Get help.
To you that give the court the chance to consider them and the people the chance to consider them. That was the point in saying waive speedy so that we can do this in a manner of time where we can consider all of these things. So I'm going to ask you again, and the reason I'm doing that is because I see the complicating factors in this case. This isn't an easy case for a lawyer, much less somebody who's proceeding without one. So I'll ask you again, is it within the purview of your thinking to consider waiving speedy so that you can have the time and the court can have the time to actually consider the motions you filed?
Your Honor, I really appreciate you even speaking to me about this because I mean that you even read the motions is just I'm overwhelmed.
They love me. They really love me. They read my motions. Yeah, it's her job, dumbass. My God, I can't wait for this person to get convicted fast enough.
I mean,
Mr. Crown, that's my job. I have to read the motions.
Well,
I'm not just ignoring them. When they come in, and I don't just not read them. Of course I read them.
Well, I'm glad to hear that because, when you're outside the system and the way the orders have come down and the way, I've sensed so much hostility and just so much antagonism. And I just want to tell Your Honor that I have considered all these things as deeply as possible, and I've been honest. You know, I've spoken with Mr. Sherman and Ms. Norwood about the issue.
Tell me,
just that the problem with speedy trial is a problem of survival, ma'am. And, you know, I used to make my living, living in other countries under a different economy. I could have a beautiful place for $350 a month and live a good life, as you can see, Your Honor, I've never caused any trouble whatsoever. I don't even have a parking ticket. I mean, I don't even speed. I really had everything under control, but COVID destroyed that. And I used to just use my van for a couple of months in the summer before I got another job and went back to work in the school year the next year. But when COVID destroyed the teaching business, especially, and the Chinese economy was ruined, which is where I was living and working and making good money and staying out of trouble, you better believe that. And I was forced to realize that I'm here in the United States and I have to survive. And I had, Andrea Mari's had let me use his address for a long time. And you have to have an address. You have to be a legitimate person to get a bank account, to get insurance, to do anything in this world. And I wanted to get away from him. I wanted to find my own way.
Okay, I want you to be very
and
careful about talking about the facts.
All right, I understand.
Of the victim.
I'll focus a little closer to the survival issue. So when the only housing you can afford is a vehicle, because the money that I made from teaching is like in an account, okay? And all I buy is fuel and food. I mean, I haven't been to a restaurant since before COVID. I don't go to restaurants or anything. I'm telling you, I go to the park in the morning, I do my exercise, I watch a few shows, and I go to sleep. I mean, that's been my life since COVID. Now, things are starting to loosen up, and I've been looking for other opportunities, trying to find housing, trying to find an affordable place to live, looking for other things I can do to make a living. And I wasn't able to pull it off except for like part-time things online, like $7, $8 an hour kind of stuff. And so when you live in a vehicle and you're poor and don't have income, then the problem is that here in Boulder at about the second week of October, I got to get out of town because I can't survive anymore. It's too cold. My van is just a normal van. It's not equipped for winters and icing in the morning and things like that. So as I explained to the prosecutors, it's a matter, I have to be out of here by the second week of October. Or I mean, if you guys are going to throw me in jail or prison or whatever, well, I've got to be there before then because it's really hard to survive. And normally I would be out of here by then and I would go south, which is what I've been doing. And I would go down to Nevada, Arizona, and New Mexico. And then in the spring, I could come back up and then maybe even get up into Washington. And that's the way van life is, And I'm sorry that's, I'm good at traveling, languages, dealing with people from other cultures. This is, I'm capable of living that way and taking care of myself. And most of all, Your Honor, staying out of trouble, okay? Staying on the right side of the law. I don't even have a parking ticket because I'm so careful about parking. I don't even park 1 minute past the 3-hour limit or anything. I'm careful and I like living that way. And I like law enforcement and I've always supported it and always cooperated, even in this case.
Yeah, that's great, Patzilla. What you got here is 2 pending felonies. Get to the point.
I've cooperated every single time, never wouldn't even dream of failing to appear.
So what I hear you, I'm sorry to interrupt you,
yes,
but
ma'am.
what I
I'm
hear,
sorry, ma'am.
No, not at all.
Yes, ma'am.
What I hear you saying is that your concern is being here into the winter because of the living conditions.
No, yes, ma'am. Well,
if we were to,
if I waived speedy trial, according to Ms. Norwood and Mr. Sherman, and I did speak to them about this. I didn't hide from this issue. We talked about this, frankly. And Mr. Sherman was thinking at first dates in December. And I know, and you know what? He's not stupid. He's done this a million times. He's a professional. He knows how long it takes to get on the calendar. He knows about the judges. He knows, what it takes to get things done, these motions and so on. And he was honest with me about that.
Well, Your Honor, may I interrupt just briefly? Sure. I have talked to Mr. Crown about this extensively. And he's told me the same thing he's telling Your Honor right now, that he's very concerned about being here in the winter, which I understand given his living conditions.
Sure.
If I may propose an alternative to waiving speedy,
sure,
we can also toll speedy, and we can set that speedy date to the second week in October, meaning that we would need to bring this case to trial by the second week of October. If we haven't, then obviously we're violating speedy. Now, obviously that's subject to the court's availability and to its scheduling. I know that things are starting to get full on the court's calendar. However, if we could squeeze this in potentially in late September or early October, I think that this would allow us to make sure that Mr. Crown has the time, not just to submit more motions and to have the court consider it thoroughly, but to actually set a motions hearing date. And I agree with the court. I usually wouldn't say this, but I think there are some motions that are very worth litigating. But I think we would kind of be able to successfully accomplish litigating those motions while at the same time making sure that we're bringing this case to trial before Mr. Crown needs to get out of town if he's acquitted at trial.
There is one other reason why I didn't want to waive speedy trial. Did you want to hear about that?
Well, let me hear about that proposal.
Yes, ma'am. Well, it's the first I've heard of it. It's certainly something to think about. Since the last time we talked about it, I've really hustled. I mean, I'm not sitting around, Your Honor. I mean, I'm in that library every day, all day, working on this case every minute of my life, okay? And I mean, I've got to go shopping. I've got to get fuel and food. But I mean, other than that, that's all I do. I mean, there's no more time in the park for me, okay? And I believe that I can forensically show the jury that I don't have this cryptocurrency and that I didn't take it. And that means that, I mean, I really believe that. And even more than that, I mean, stuff like I have in my Frank's motion and all, I think I can show the jury some really interesting things. And I think that I can show them that I'm not guilty and that most of all, I mean, if I had the cryptocurrency, I wouldn't even want it. I'd give it to him right now, and to be able to show that right now tells me something, tells me that it's time to do it. I was in jail for a long time and I had some pretty hard time and I don't want to go back to jail, but if I have to go back to jail, I want to get it over with while I still might be young enough to survive, because I think I'm going to die in there because what happened to me, I mean.
All right.
Okay.
That's getting off.
So I'm just going to tell you that Boulder County Jail is no joke. Some people say it is, but it's not for me. And especially I'm not a criminal. It's hard for me to deal with that environment.
Okay. So what I understand you saying is you're ready to go.
I mean,
and that's fine.
There are some things that I've got to wrap up. There are a few things I'd like to wrap up, like this Korean language thing. I mean, 만은연전에 한국에서 씁니다. 한국어 말합니다. 알겠습니까? I mean, there was a time, ma'am, when I spoke and read Korean every day. I lived in Korea.
Okay,
I speak Korean.
Mr. Crown.
You can't let the people defraud the jury and tell them the stuff is Korean.
Nobody
when it's
cares.
Not Korean, and it certainly isn't an apology. And Chinese too.
Mr.
That's
Crown,
my language.
now you're talking over me because I'm trying to interrupt you.
I'm sorry, ma'am.
It's just not a thing that happens in this courtroom. And I recognize I interrupted you first, but
I'm sorry, but these are the things on my mind. And this is the reason why I'm
Yeah, great. I did a full drunken stream from Busan with my buddy. Nobody cares.
thinking about speed trial and why I'm thinking that I should just get in there and get it over with and let the chips fall where they may now, you know? And so that's my conflict. Can I decide right this minute? I mean, I don't know.
That's the timing because we're a week from trial. So the timing is now. And you know, it's been on the radar since June 2nd that it would give you time to sort of sort these things out. But if you're ready to go, you're ready to go. It's not going to be, it's not going to be easy. And there's no, as far as the court's concerned, there's nothing really more to be said about the Korean. I've ruled on that.
You have, ma'am, you have, and I'm going to do my best to bring it out in the right way. But I must have done something technically wrong or whatever. But I mean, forget about my knowledge of Korean. I mean, there's an expert, a certified translator has confirmed what I said.
Mr. Crown?
Yes, ma'am.
It's not time to relitigate things the court has already ordered. So one of the things that the people point out, well, we'll get into motions, but it sounds to me like the other option that I thought of, and I don't know what the people's position is or Mr. Crown's position is this could be a trial to the court. It doesn't have to be a trial to a jury. You have a right to a trial to the jury. The people now have certain rights to a jury. And I don't know if you all have thought about this or not, but if we did there's a couple of reasons why I'm offering this. One, a trial to the court, a lot less time involved. No jury to sway. You're swaying me. So it's a trial to the court. I would make the decision on guilt or innocence. It would be, in my mind, a 3-day trial as opposed to a 5-day trial. This court has had a sudden family issue, so I'm not going to be able to try the case. It's going to go to another judge, and that's fine. All the judges are pretty good here, so you're going to be in good hands either way if it goes to a jury. But having a trial to the court, I'm familiar with the case. I would keep the case because I could do it within 3 days. I guess, Mr. Crown, I could give you a little bit of time to think about it, maybe a couple of days. But that's another possibility, and I'm not sure the people are interested in anything like that. I could get your position if you have one, or you guys could talk about it.
I'd be fine with that, Your Honor.
All right. So, Mr. Crown, it's also in this court's mind, it's a little bit easier to try to the judge, right? You're not having to convince that. Well, there's no voir dire, so there's none of the jury selection piece. It just goes right into evidence, really, or opening statements, evidence from the people, evidence from the defense, rebuttal evidence from the people, closing statements, and then I get the case. As opposed to voir dire, selection of the jury, all the laws that apply there, things that you can and can't do there, those types of things. And it takes a while to pick a jury. I'm thinking, in this case, maybe a half day, maybe 3/4 of a day. So that's another option that we have. And the people don't object to that option, but it's really up to you.
If I may, ma'am,
sure.
If there's a bench trial, do you call them bench trials?
Yeah, that's
okay,
another
and
way
I
to
noticed
say
how
it.
you said voir dire, which is correct in French, and where I come from, they call it var dire. But anyway, just for your fun. And would the bench trial be the same date?
Yes.
God.
As so it would start August 3rd.
Start on Monday.
August 3rd, August 6th.
Yep.
The most annoying person on the planet.
Okay, so there are 2 issues I have to decide soon. One is Speedy, and Speedy told with.
Put this guy in a cell with Daryl Brooks. That's perfect. Let them talk to each other.
Let me just. It doesn't look like we have October dates. We have November dates. The October dates are not before. Hold on, let me look here. October dates are not until. Why can't I see this? Well, let me. Hold on one second. I'm sorry. I think I'm missing part of the note. All right. That's because it's in my pocket. So the only October date we have is October 26th. Did she cross that out? So we would not meet the deadline within which you'd have to be gone if we told Speedy to October 26th.
May I ask a question?
Sure.
About tolling?
Yes.
Now, I had a little bit of experience in civil stuff, and we didn't have speedy trial on that. And I never, I know what it means theoretically, and waiving speedy trial is easy to understand. Tolling speedy trial is a little bit different. And I'm going to admit my ignorance about it and what it really means. Does that mean that what does it mean to the court? If you could just.
So tolling speedy.
Oh, we knew you were ignorant. You didn't have to tell us.
Means that we would toll the speedy trial deadline for a certain amount of days. So instead of it being a 6-month waiver, like right now, if you waive speedy trial today, speedy trial would be January 27th of next year, because that's 6 months from today.
If I waived.
Right.
Okay.
And then if we told speedy, we would be tolling it for the days up until the trial set whenever, but the speedy trial would be the number of days until that trial. So then your trial right, if I'm thinking about, your speedy trial deadline would be whatever the amount of days are to that date.
Meaning, if I might clarify, that if the trial doesn't occur on that particular day,
it would
the
have
trial
to
is set for,
right?
Then I don't know what they do at the state. I guess the state says we're not going to have a trial. I don't really know.
The court is the only one that can continue.
Oh, I'm sorry. But if so, that date that trial is set for, let's say it's October 26th. If the trial doesn't happen on that day, is the case dismissed?
No. The case would not be dismissed unless the people said to the court, the only people that can dismiss charges, the people can dismiss charges. They are the only ones.
I see.
They control bringing charges. If they feel they don't have enough evidence or for some other reason, then no, the case doesn't automatically get dismissed. There's no shot of that unless the people decide that they're going to dismiss it.
But if there's no trial on the date that speedy trial passes, what happens?
So it's not told until the date of the trial. It's told until, and Mr. Sherman, you can jump up in here too if I'm not.
What I mean
I think I'm right, but what would happen is for some reason that case didn't go, then there would be a certain number of days from your tolling speedy to now until that day, and then speedy would run like 3 months beyond that date. To get the trial in, if that makes sense.
So they'd still have 3 months to.
Well, they'd have however many days we'll be tolling speedy from today until, say, the October date.
Oh, how many days do they want to toll? How many?
Well, I don't know.
We don't know yet. Okay.
Does that sound right?
Do they have an idea?
So I think theoretically, we were to pick that October 19th date, we would toll it to like October 20th or 21st.
Right. Okay. So then if we didn't go on that date, then your speedy trial would run.
So October 19th is the date we're aiming for?
Well, that's the only date. No, it's October 26th.
You said.
Yeah.
So I think we would toll it till the 27th. And
so that's correct.
I haven't looked too deeply into this issue because I haven't had it come up, but I do think there are serious problems for the people if we don't bring this case to trial before speedy.
That's correct.
I don't know what those consequences are, but I'd have to do further research into that. But the reason that's never come up is because that is something that we try to avoid
right,
at all costs.
Sure. So technically speaking, what the district attorney is asking you to do would be to toll speedy until a little bit after the trial date. So like maybe the following day that the trial would have to go. And if the people for some reason didn't go by that date, yes, the case would be dismissed. But I've not seen that in my tenure as the court, where the people aren't going to forego a speedy trial right. They're going to get the case in, if that makes sense. So if we toll speedy until October 26th, that'll be I would usually require that you told Speedy at least until a week after the trial, because the trial is going to take 5 days if we go to a jury trial. Does that make sense?
It does, ma'am. I'm sorry to be pushing on these details, but I guess that's why we're here today.
For sure.
I just thank you for even speaking to me about this so frankly, because I don't have anybody else to talk to about it, you know?
Well, I could have appointed an advisory council to you and you've let that deadline go.
Well,
right?
I listened to the audio about that.
Well, no, I filed an order with regard to advisory council.
What Your Honor said was that it could be done, but then Your Honor decided not to do it.
Well, then I filed an order saying that advising you that you could have advisory council. And I did not receive your request for advisory council within the timeline the court stated.
I don't recall that order, and I did just recently listen to the audio of the hearing.
No, it wasn't the audio.
Nothing I can do about that. There's nothing.
It's not the audio, Mr. Crown.
Yes, ma'am.
I filed an order talking about it. And you've seemingly been up to speed on all of the filings. Did you not see the court's order with regard to advisory council?
No, ma'am, I did not. It could still be in my mail down at the homeless shelter. Usually, I'm going to just say that usually Miss Norwood emails me the orders, but this was before maybe Miss Norwood came onto the case or before she was introduced or before we were, because Your Honor, as you recall, as I had communicated with your assistant, Miss Hyman, all of Mr. Sherman and Miss Norwood's products go through the e-filing system to which I have no access. And I'm not allowed to use that system because it's only available to tenants and family law matters. And therefore, everything that comes from Your Honor gets mailed to the homeless shelter, and there's some delay in that. Okay. Now, I have been out there a couple times to get my mail and did not see that order. But Miss Hyman, realizing that and having discussed it with her, has on several occasions, as a courtesy, emailed me your orders, especially recently. And Miss Norwood has also, as a courtesy, usually they're victorious, so they're just telling me that they won. But Miss Norwood has emailed me orders and documents that they've filed because they know, we all know, I don't know if Your Honor knows, I can't get anything in the emailing. I've been denied. So in the e-filing system. Mm-hmm. So if Your Honor did issue an order about that, all I had to go on was the audio recording, and that's one reason why I got the audio recording, because I didn't want to throw anything in Your Honor's face about Your Honor's rulings that I didn't really know. I'm not going to say Your Honor said this or Your Honor said that unless I've got the actual audio recording. Now, that's the...
All right, well, let me jump in. The court issued an order with regard to appointment of advisory council on June 18th of 2026. And I asked, what I said was I failed to ask if you wanted advisory council appointed to support you. And then I explained what advisory council was and that you would have to submit an application to determine your indigency to appoint advisory council. And I said, if you want to do that, then you would need to file the application within 7 days and let the court know that you wanted advisory council. That was June 18th. And at this point, advisory council wouldn't be able to assist. It's too close to trial. Although, again, another reason to waive speedy trial. Because the court could certainly appoint advisory council to you. You're still responsible for trying the case, but advisory council would be here with you.
I understand, ma'am, and I appreciate that, and I thank you for that. And, we went through this public defender thing before, and I don't think I can qualify. And the public defender, I've had two of them from this local office, and both of them clearly told me right to my face that they do not want to get into the voluminous discovery of this case. They do not feel that that's their job, and they refused to do so, and they refused to give it to me. And they said that they just weren't going to do that. So,
And who are you talking about?
That would be And I'm so
Ms.
sorry.
Malcolm was one of them.
Yes, ma'am, and Colin Sullivan. And they just.
And who? Oh, Colin Sullivan.
Yes,
Okay.
ma'am.
And
And-
you're saying to this court
Yes,
that
ma'am.
your attorneys told you that it was not their job to look at the discovery in the case?
Miss Malcolm specifically stated on numerous occasions that she did not, in fact, I didn't want to waive my preliminary hearing, but she insisted. She said, I'm not going to read 350 pages of discovery. Now, at that time, she was the one who said 350 pages. Now,
Right. I don't need the full
yes, ma'am,
explanation.
but I just want
yes
you
or
to
no.
know that it's more like thousands. Okay. I mean, there's a lot.
Yeah.
I mean, I got a document just not long ago that was 460 pages. So,
All right.
so the bottom line is that, yes, ma'am. I mean, I wouldn't just make this up.
All right.
Yes, ma'am.
I'm just clarifying.
It's absolutely 100% sure. On numerous occasions, she said that she was not prepared to go to court on the. She didn't even know that I was in Nevada at the time of the crime by the time preliminary hearing came up, and she said we have no choice but to waive this. I didn't know what to do. I was in jail. I was
Okay. I don't.
Yes,
again,
ma'am.
Mr. Crown, I don't
And,
need
and
the
so, yes,
details.
ma'am, I'm going
Okay.
to just reiterate right here on the record, right in front of Your Honor and everybody else, that she on numerous occasions stated that she did not want to read 350 pages of discovery.
Okay,
was
I
not
got it.
taken
That's a
into it.
yes answer to
ma'am.
my question.
Sorry, ma'am.
That's all right. All right. Well, it looks so Mr. Crown, I'm willing to give you some time to think about a trial to the court.
Yes, ma'am.
But I think we need to have another hearing on the motions. People filed motions in limine. I don't know if you've received those.
I did. There was a motion in limine regarding statements of the proffer agreement. Is that the one we're talking about?
I filed some additional ones.
There's
yesterday.
been more filed today.
Oh, well, I haven't. Obviously today I haven't gotten anything. Usually, like I say, Miss Norwood will give me, by email, a copy of what's being filed. I mean,
All right.
I'd like to see it.
Of course you would.
And
That
I'd
makes
like
sense.
to at least think about it if I could.
All right. Here's what we're going to do.
Yes, ma'am.
So do the people anticipate any other motions in limine?
No, I hope not, because today's the deadline. The only thing I wanted to address on the record, other than those mills, was the people do plan on admitting a jail call that Mr. Crown made when he was in custody in Seattle. Obviously, we'll redact as much as we can.
Has that been disclosed to Mr. Crown?
Yes, he has all
Okay.
the discovery. I've dealt with this in other courtrooms. Sometimes we refer to the call as a detention call as opposed to a jail call. But I just wanted to put the court on notice about that. And if we want to address that now, we can, or if we want to address it at the next hearing, we can do that too.
Okay. Why don't we give Mr. Crown, so a couple things, Mr. Crown. The court's going to find another, actually, we had set this on Friday. I'd like to know before then if we're having a 3-day trial. That's going to matter to the entire courthouse right now. We have a lot of trials set. So, Mr. Crown, I think I'll reset this hearing for Wednesday. Do you have anything, Mr. Furman?
I'm available most of that day, Your Honor.
Your Honor, I have to work from home that day because my dog recently got a surgery.
Okay.
If Miss Norwood could be here in person and I could appear virtually, then that would work with the people.
That's fine for the court. Let me see. And Mr. Crown? Shoot. We could do it on the lunch hour. I'm in trial, a civil trial I forgot about. So we could do Wednesday at noon.
That works with the people.
All right. Does that work for you, Mr. Crown?
If that's when you want me to be here, I'll be here.
All right.
That would also just be very helpful for the people to know by Wednesday whether or not this will be a court trial or a jury trial. We have one out-of-state witness.
Okay.
And because of how long we anticipate voir dire to take place, we're going to slot him in on Tuesday.
Okay.
Obviously, if there's no voir dire, we would want to get him in on Monday. So just the sooner we can let him know that, the better.
All right. So we will have this hearing at 12 o'clock on Wednesday, which is the 29th. And Mr. Crown, at that time, the first thing I'm going to ask you is, are we having a jury trial or are we having a trial to the court? So I want you to think about it. And then we will address any in limine motions at that time.
Just want to check the order. I mean, I had that motion in limine about the Korean thing. I think Your Honor actually just.
We can go through all of that at noon on.
Okay, I was just checking to see if there was an order actually denying it. I don't know, the order I have here.
Oh, tell us about the Korean thing. Do you speak Korean? We want to know. What are your travel habits? What are your hopes and dreams?
Here is that the people shall respond. But I don't know if there was one after that. I just can't remember if Your Honor denied it or if it's still active.
I didn't deny it.
Oh, okay, that's what I thought. Too. I mean, I'm just making sure.
Let me see what well, let's see. Hold on one second. Well, I think, I can't find it. There's been so many. Hold on one second. Do you know when I finally issued an order?
I have an order.
No, not you.
Oh, I'm sorry. I'm sorry, man.
All right. That's okay. I'll find it.
Your Honor, if I may, I'm showing a response from July 15th wherein the court said that it needs to hear additional foundational evidence. And I read this to be basically reserving ruling until trial.
Yeah, that's what I'm looking at. So July 22nd, it's kind of a long motion, but I granted the motion in part. And the motion that I granted in part was your motion to withdraw the court's authorization for expert funds. And then the other piece the court found was that the notice of filing of Korean language statement and certification is part of the information that should be disclosed to the prosecution when endorsing an expert. However, it doesn't suffice as an expert witness endorsement that's been timely filed. The people objected insofar as you were trying to admit that as evidence or you were trying to endorse the person who made the statement. Because you're out of time. You didn't endorse an expert witness in time. But what the court said, let's see. Hold on. Right, so that's correct, Ms. Norwood. What the court said is that I would consider the motions denied until I received evidence at trial, because it may be moot. If you are trying to, I don't know how you're going to try to get this evidence in. I don't know how you're going to have foundation to get it in because you didn't endorse this witness for trial. So it's very likely that it's not going to come in. But I can't do that until I know how you're going to try to lay the foundation to get it in at trial. Does that make sense?
I hear what you're saying, but
there's no but.
It's just
that's it. That's the order.
Well, the order is the order, but I mean, can it be that in a courtroom in this country, in this state, in this place, that someone could put forth a gobbledygook and say I'm sorry in some foreign language? I mean, when it's not.
Well, that's where cross-examination comes in, and that's also where deadlines come in. Had you filed an endorsement, a proper endorsement, we wouldn't be having this conversation, but you didn't. So it's not the fact that it's a court in this country, in this state, that's doing something to you. There are laws and rules that are required when you're going to trial. You decide.
The world frightens and confuses me. My primitive mind can't grasp these concepts.
Not to apply to a public defender or have an attorney 2 months before trial was going to start, and then decided that you didn't want the time to do the things that needed to be done before trial. That was your decision, Mr. Crown. This court begged you to practically to waive speedy trial so that you could do things properly, and you didn't want to do that. And one of the things that you have to do properly is endorse witnesses, as particularly expert witnesses, because you have to put the parties on notice that you're going to call that person. And there's a timeline for doing so that you missed. That's a rule. That's a criminal rule of procedure that you missed. And you're making decisions in your cases that are causing you to miss deadlines and that are causing you to think that this court can just accept what you're saying as evidence. And you know, having been an attorney, that is not how it works. So while I appreciate what you're saying in some way, I can't let it go that you think that it has to be a certain way in this courtroom. What it has to be is following the law. That is what it has to be. And that is what will happen. So that's the court's order. It was issued on July 22nd. For your information with regard to the advisory council, the court emailed you the court's order with regard to advisory council on July 23rd. Or maybe it was June 23rd. Let me look. June 23rd. So that's going to be the order of the court. I will see you all on Wednesday. Mr. Crown, what am I going to ask you first?
You're going to ask me if it's going to be a bench trial or a jury trial, and I think you're going to ask me about the speedy trial.
No, it sounds to me like we're going to trial, unless you want more time. Then if you come back after thinking about it and say, Judge, I want to toll speedy, we can go to October. It looks like the 19th is available. We can go to the 19th, then we'll talk about that.
Well, I'd like as much time as I can have to consider that. I mean,
well, you have exactly until Wednesday at noon, Mr. Crown, to consider it, because we're going to trial on Monday, and the people have to prepare, and you have to prepare.
I am preparing, believe me.
Okay.
And I do have a question for Your Honor about court procedure, if I could.
I may be able to answer it, I may not, but go ahead.
I don't want to overstep, but if I'm convicted by the jury or by Your Honor or whoever tries the case, am I put in shackles and put right in the jail, or because I'm on bond, am I allowed to stay out until sentencing, or is there any time whatsoever to manage my affairs before anything takes place? And will Your Honor accept or receive, or is it normal to prepare a appeal bond documentation for the court? What I'm just trying to get at is just logistical. It's just human things, like I have my van and my worldly possessions to deal with. And
if I were you, because I can't answer this question right now, it's altogether possible, and I would get the people's position, which they probably don't have right now, if they would want to remand you based on the conviction. And then it would be up to the court to determine whether or not you could stay out on bond until sentencing. So it's altogether possible that you could be remanded that day after trial, but it's also possible that you won't be. So I would have you get your affairs together. That's what happened. That's my advice.
so I just have to be ready to come in here and be taken away that day. That's the way it is.
The charges carry sentences that are in custody. It's up to the court to determine what the sentence is, and it's up to the court as to whether or not we'll proceed to sentencing, which I likely would not do on an F3. There's information this court would like to have before doing that. But the real issue is whether or not you can remain on bond until a sentencing hearing. And that's going to be something that the people can consider after going to trial and hearing the evidence and all of those things. I'm not going to make them decide whether or not they agree to allow you to remain on bond or not at this time.
I see. So it's the people's feedback, which is...
Well, the people have the ability to, yes, it's not their feedback.
Yeah, I don't get any sense whatsoever that this person was ever an attorney. I hear that they said that, but I just find it incredibly hard to believe and to know that little. I could not practiced law for 20 years. You could wake me up at 4 o'clock in the morning and I would make more sense than this person.
I would want both of your feedback because the court has to consider both parties' positions on the issue.
I see. And Your Honor got a notice regarding the multiplicity. There are 2 counts, 2 crimes alleged, or 2 counts in this case.
Crown, I'll consider all of those things on Wednesday.
Yes, ma'am.
All right?
Yes, ma'am.
So whatever outstanding motions there are, whether they're motions in limine or the multiplicity motion, we'll talk about them on Wednesday. I don't think I have the people's position on that.
I was afraid
I might not
to put it in like a motion with a demand for relief because at that time, Your Honor had issued an order about motions and I just didn't know what to do. I didn't want to offend Your Honor. So I filed defendant's notice of multiplicity in lieu of motion. And I explained the details and the law that I found, but I was afraid that Your Honor would like sanction me and throw me in jail. And I was afraid. And then I saw some other motions come up and I thought, well, there must be 2 kinds of motions in Your Honor's mind. Some that
You should be afraid. You're facing felony charges. You should damn well be afraid.
you feel are appropriate and some that you
Glad you
feel are
figured
not.
that out.
So now I was bold enough to file that motion to compel, but I followed behind the prosecutors. But I mean, it's a serious issue that should be decided before trial. It's big, you know, and so if you want to, I mean, Wednesday's fine. I mean, I just want it to be at least decided or thought about. I did try to speak to the public defender. I did speak to the public defender about this issue months ago, but she didn't want to, I mean, she told me some things about it. I don't know if I should say, but I mean, you know, she did have an opinion on the matter. And I thought she was going to take it up with Mr. Sherman. And she said she was going to, but when I looked in the court record, as Your Honor told me to do, for things that had happened, including certain documents she said she was going to file on my behalf, they weren't there, and I filed them. I filed one on my
All right, I'll consider. I'll take a look.
So I just had to bring it up on my own.
I've already looked at it. I'm not sure if I ordered the people to respond. I probably did.
To that particular thing, I don't think.
Yeah, I did. I ordered
did?
people to respond July 21st, and they probably did. But I have not looked at it yet.
Well, the multiplicity was filed on July 25th, ma'am.
Right. All right. Well, we'll be in recess until Wednesday, and then we'll make some decisions.
That's good. Thank you.
All right. Thank you all
For speaking to me, ma'am.
Of course. Court calls 25 CR 1044 concerning Paul Crown.
Your Honor, Emily Norwood, Alex Clark, and Brad Sherman for the people.
All right, thank you. And Mr. Crown is also present. He appears pro se. Mr. Crown, you can just have a seat right there. That's fine. All right, this matter comes on. Technically, it's a pretrial conference, but the court has issued an order, had issued an order yesterday with regard to the motion that the people filed. The court did find that the people, hold on, let me just pull it up. And Mr. Crown, I see that you filed a number of motions. The court has not been able to consider any of them on today's date. Hold on. As you can see, I'm in another trial. So, but the court was able to review the people's motion yesterday with regard to their motion to continue based upon witnesses that they were unable to obtain as they were searching for the ability to comply with the discovery requests that Mr. Crown made. So the court did grant that motion. Mr. Crown, what the court is interested in at this point is finding out if you are able to, or whether you would like a trial to the court or a bench trial, or whether you want to proceed with the jury trial on October 19th.
Jury trial, ma'am.
Okay, and I'm going to have you use the microphone there.
Which one would you prefer, ma'am?
Right there at the podium, please.
Yes, ma'am.
All right, and I don't think the record caught it, but I think you said you'd prefer to have the jury trial.
It looks like I better do that. Yes, ma'am.
Okay, and that's totally your call. I just want to make sure what we're setting for.
Ma'am?
Yes.
If with that motion to compel, I mean, I would withdraw it if Your Honor is saying that the continuance is based on that. As I told Ms. Norwood by email, I mean, if the discovery is forthcoming or whatever, I mean, I didn't intend to I don't believe that my motion caused a continuance. And the motion, you know, but
go ahead.
I just wanted you to know that, I mean, it's not critical. I mean, I'd withdraw it, you know. I just ran into a timing issue where trial was coming up and there was, you know, those messages, I could use them. But I mean, if I can't get them, I can't get them. So I just wanted you to know that I'm flexible on that motion to compel. And I only filed the motion to compel, as I told Ms. Norwood, as a timing issue, and was perfectly willing to withdraw it and drop it if we could talk about getting that discovery or whatever.
Okay. Well, where we're at now, Mr. Crown, is the ship has sailed. The court issued the order yesterday, and any order coming from this court affects every other court in this courthouse. And so at this point, it's too late to take that back. I understand, but didn't understand when you filed the motion yesterday that it was something that you would be willing to not go forward with if the people couldn't get the discovery. That wasn't information this court had. That said, even though you would be willing to withdraw the motion, the court's already entered the ruling based on the information that the court had at the time, and now the schedule for the court is set. And so that's where we're at. And frankly, I think that you are absolutely entitled to that information if the people can get that. And I think it's something that you pointed out would be beneficial to the case and beneficial for your defense to have. And I agree. And so that's where we're at this point. I don't think that it's appropriate. What the court can do with making a finding pursuant to 18-1405 6G1 is the court can continue it for 6 months. The court was persuaded by your concern that being here during the winter is something that you would be concerned about. I think October 19th keeps you out of that position at this point, and so that's where we're at. So the court is going to continue the matter. I've already issued that order. I'm going to continue it until October 19th, and hoping that that weather stays the way I think it will, based on last winter. And if for some reason we get weather that's showing the court that it's gonna be a winter issue for you, then we can take that up closer to trial, if you're concerned about that. Does that make sense?
It does, Your Honor. And and
Mr. Crown, I know that you're doing the best you can.
I am, ma'am.
I understand that. But I do think, as I told you yesterday, or whenever that was, Monday, I do think that you are filing motions that need to be dealt with. I do. I think that you've got some good substantive issues here. I think that it is in your best interest in defending the case to get the information that you're asking for.
I hear you.
You're right on track. And I think that that's really critical to your defense, which is why I think, the people need to delve into these other witnesses to find out if they can get that information for you. They can't do that by August 3rd. And even though you'd be willing to retract the motion, I don't think that's in your best interest to do. I think you're entitled to that information. That said, even more, because I think you're entitled to the information, and because the people can't get that information to you before trial starts on August 3rd, it's best that the court continue the trial. So that's where I'm coming from. It's not because, I'm trying to beat up on you. I think you caused this whole issue to happen. I think you're entitled to it. You found something when you were looking through discovery again, it sounds like, I'm guessing.
Yes, ma'am.
And you filed an appropriate motion. And you're entitled to it. It just, sometimes when you're entitled to things, when the people start rooting around to find it, they find that they're going to have other witnesses present to adequately lay the foundation to combat it.
I understand.
And to get it to you so that you have it. And I'm not comfortable. You filed enough things that I'm not comfortable at this point going forward that without the opportunity for you to get it. Does that make sense?
Yes, ma'am. And what was filed for today is all responses, except for one thing, which you told me I could convert the notice of multiplicity to a motion.
Sure.
But I didn't actually, I was showered with motions Monday and Tuesday, and I just spent all day responding to them so that Your Honor could get it on. I could get it on the record.
Sure.
What I was feeling about that, and maybe in your own time you can look at them.
I will.
But as far as the continuance goes, well, it's your call. I mean, I know that, but I haven't waived my speedy trial, have I, ma'am? Are you saying that, or didn't mention that? I don't feel like I have. I didn't intend to.
It's not about that. If you read the court's order, pursuant to 18-14056G1, when the people need material witnesses, it doesn't matter whether you waive or not. The court finds that it's appropriate that trial get continued so that the people can get their material witnesses in here. And technically, I can continue it for 6 months because technically the speedy trial right would start over. I don't want to go into January. I don't want to go into December to set the trial, which is the timeline that we would be looking at. What I want you to understand is the clock starts over.
Based on the court's told, as we spoke about before?
Nope. That's a new issue that's on the table. You need to re-review the court's order. But I'm finding that the people need material witnesses, that they have filed a motion because they need material witnesses that they can't get here by August 3rd. And that's really based on the motion to compel. That said, I've made the record with regard to why. I'm not going to retract the court's order. I'll have you refer to the court's order to understand why the people get the continuance that they get and why speedy is now reset. Does that make sense?
I did review the court order, and I didn't see anything about speedy trial.
You just need to re-review why the court found what it found. The statute is sitting there plainly in the order. So you can go back and read that statute. All right? And I actually quoted from the statute. So I'm going to have you do that. I'm not going to take it up right today. But what the court will also do is, Mr. Crown, if you file a motion, the court's going to consider the responses to the motions in limine. I'm going to rule on the record on the motions in limine, including your written responses. And if you find that you want to be heard on other motions that you filed, you need to file a motion for a motions hearing on those motions. All right?
You mean the ones that were ruled untimely?
That's correct.
Denied on those grounds?
That's correct, because we now have more time.
See.
And to go to trial. And there's a very strong likelihood this court would be able to set those motions for a hearing.
Okay. And just to be clear, have you ruled that I waived my speedy trial?
No, I did not.
Okay. So it's a matter of statute.
Yeah.
So we're talking about a speedy trial is separate from the statute.
It's not necessarily separate, but again, I'll refer you to the statute that the court relied upon in its order. All right.
Okay.
And so go back.
I'm trying to be difficult, Your Honor. It's just all new to me. I've never had to deal with a speedy trial before.
Okay.
So it's a little bit confusing, but I'll get into it.
Let me ask you. I want to give you the opportunity to have advisory counsel appointed. It doesn't mean that you're still running the case. They're there as advisory counsel. Is that something that you would be interested in?
Well, sure. I mean, especially for things like the technical issues, like I contacted this lawyer at the Bar Association to ask if there were tutorials on, how to like properly introduce evidence in your courtroom, how to use the technical devices that there are now. I mean, the last time I was in court, was the Stone Age.
Yeah, you need an attorney for, like the law stuff. Like, rules of evidence, trying the case, opening argument, everything.
We didn't have any of this stuff. So, and this lawyer, Mr. Ravik, who knew you, and, told me a couple things about the HDMI cable or whatnot. But yeah, if I had somebody I could talk to about things, that would be lovely, but I don't know. I can't fill out applications for indigency if I don't think I can qualify. And I wouldn't want the particular public defenders who were assigned to my case who didn't want to defend me.
This wouldn't. So, well, you have to be indigent for the court.
The only way you wouldn't qualify is if you're absolutely guilty of the crime you've been accused of and it got a bunch of crypto stashed. Other than that, you're living in a van down by the river.
To provide counsel, advisory counsel, and you don't think you're going to qualify?
I mean, I'm too poor to afford like a $10,000, $20,000 lawyer. But I mean, I do own a vehicle. I pay for fuel and food. I mean,
Well, I'm going to ask you to go ahead and fill out that application that the court pointed your attention to when I issued the order with regard to advisory counsel. I mean, it can't hurt, right? So
Yeah, it can hurt. It could provide the information that helps the prosecution convict him. He can either perjure himself for yet another charge, or he can turn over the goods on why he's guilty of sin in what he's been charged of.
if you would do that and file it, I will take a look and see if you qualify for appointment of advisory counsel. Those are private attorneys. So they're not the public defender's office. And it's totally up to you. I'm just telling you right now, there's an application right there in the lectern you can access.
I saw one here. And I
Okay,
believe it's
take
right-
that and apply if you'd like. I can't order you to do it. I can't even
Appreciate that.
twist your arm, but what I can do is tell you that any attorney at this point would be better than you proceeding on your own. And if you're indigent, I will appoint advisory counsel to you, but I have to see the application first. Okay?
Thank you for that. Yes.
All right. Any other questions?
Yes, Your Honor, there is. And it just came. Yes, Your Honor, there is. And it just came up today at the clerk's office because I was the first person in there to make sure
If you were a tree, what kind of tree would you be?
I got those responses to you because I didn't know if we were going to get into those motions today. And it's pretty complex stuff. I mean, those motions were heavy.
Okay.
And
Go
all
on with your next question.
Yes, ma'am. Okay, so the clerk told me that, there was a motion to amend counts and an order on it, and I wasn't notified, and I didn't even know that this was happening, and it's pretty serious. And as I mentioned to the court in the last hearing, and as we've discussed, and as everyone knows, I am not entitled to access to the e-filing system. And this is just, I mean, I don't make the rules. I mean, I tried to, I signed up for it, but I was told very clearly by the clerk's office, and I called on the phone as well. I think I talked to the clerk, okay? And as a pro se litigant, I can only get involved with landlord, tenant, and family issues on that system. And all of the things that are sent out from Mr. Sherman's office, I'm not disparaging Mr. Sherman or Ms. Norwood. They're just doing their job. Everyone else gets the e-filing, but I don't. So now sometimes your assistant, Ms. Hyman, emails me an order. Sometimes Ms. Norwood will email me a motion or an order, but some things aren't coming through. And let me explain why this is important.
You don't need to explain why it's important.
Well, I mean, this is something that I just have to ask the court to say
I
something.
automatically know that it's important.
Yeah, but
you don't need to explain it.
But it's more. There's an issue attached to that, Your Honor.
Okay.
And it's important because under the theft statute, I'm entitled to a bill of particulars, which tells. I mean, they've changed the dates of these charges to a huge window of many months, like almost a year, and I have 13 cases for the cybercrime thing, and I have the statute on the theft statute. The prosecution has to tell me when this crime occurred, because under the criminal law that I've learned, the act and intent merge. They are one thing that happened at one particular time.
It sounds like you're arguing motions.
I'm sorry, but I mean, this is important and it's huge, and I've been blindsided. And if I hadn't asked the clerk this morning, hey, are there any stray orders or anything? She said, oh yeah, there was one that just came out yesterday. And I said, what's going on here? So it's shocking. And I believe I hate to say this because I know you probably, look, I think my constitutional rights have been trod on throughout the whole case. And I think this is part of it. And I'd just like the court to consider it from that perspective. And, just God.
Here's what we can do with regard to. Here's what we can. This is how the system works, Mr. Crown, and it is difficult, and it is fast, and it does. And the court typically. So I will tell you, that with regard to the people's ability to amend the charges, it is very, very broad in case law and elsewhere. So the court granted the motion knowing that, and you don't know that because you're pro se. And I don't disagree that you're right. Almost everything in a criminal trial has constitutional implications for the defendant. So I'm not going to, what I will say from now on is I will have my clerk email you orders.
That would be great. Thank you so much. She does send me some, but not all.
Okay. So in the future, you'll get all of them. All right. From the court. I know that the people have also been sending you their things as they can.
Well, some,
but you're not the only case, right? You're not the only case that people have. You're not the only case the court has, which is why the system's so fast. All right. But, and so I understand your objection and I think to amending the charges. That said, the court is very aware of the law that supports the people's ability to amend charges, even at trial, even at the time of trial. So it's a very broad ability to do that. All right. So just be aware of that.
I am aware of that.
Okay.
If I was
stop.
Yes, ma'am.
And I'll leave it at that. You can go back and look up case law on the ability of the people to amend charges. That's my suggestion. And that's where I'm going to leave it. But I think it sounds to me like the issue is really not getting this information as quickly as it's being filed at times. And that's fair. And so the court is rectifying that by, I'm going to have my clerk send, when I file orders, I'm going to have her email them to you. It will be like receiving them at the same time the people get them because they get them when they're e-filed, right? So they have that instant sort of look at it. And you will too. All right.
Would Your Honor, just one word from Your Honor to the prosecution that, you know, if they could email me what they do, I email them. I hand deliver everything.
I don't have authority to order them to do things of that nature. So I can't do that. But I appreciate it. I mean, if the people can do it as they can, I will, ask you to do that, but I can't order them to do that. I don't have authority to do that.
See, I didn't know that. And I'm sort of probing on that because I just, these are technical little local kind of things. Where would I even look for a case on that, But so there's time for motions. And if there's an appropriate motion for this amendment, I'm not saying that they can't amend. I'm saying that the amendment is incomplete or that I'm entitled to further, that the statute, especially on the theft count, clearly states.
Sir?
Yes, ma'am.
What did I just say? I'm not letting you argue motions.
You don't want to argue the motion.
Already.
Okay, so I'll take that up later then. I'll take that up later.
That sounds like a good idea.
Is that the proper thing to say? Okay.
You can, Mr. Crown, I mean, the proper thing or not the proper thing from a pro se defendant, it's really, I'm going to try to listen to everything you bring up at the appropriate time to do so. Right now, I've already issued an order. It's not the appropriate time to do that.
Yes,
all right.
ma'am.
If I will say, if you want the court to reconsider something, you can file that.
I'm going to go look at Your Honor's orders on the previous motions that we've discussed and make, because, the time.
I'm just going to leave it at that. All right.
Yes, ma'am. That's my intention based on what you said.
Okay. And so what the court is going to do next, so make sure you're looking out for emails from the court, is I'm going to try to find a time. I think we're going to need a motions hearing in the case. I'm going to try to find a time that we can do that.
Yes, Your Honor. And for these motions that we were going to talk about today, now that it's you say you're going to handle them yourself.
That's correct.
We're now talking about, after you order on these motions, like my Frank's motion and suppress and things like that.
Exactly.
I got it. Okay.
All right. So the court is going to review the motions in limine. I'm going to review the responses. I'm going to issue orders as to those motions in limine. And I don't know if any of them requested a hearing or not. But at this point, I'm going to rule on the motions that I have before me for motions in limine.
And the multiplicity as well, ma'am, like we talked about on Monday?
Yes.
Yes, ma'am. Okay. Thank you, ma'am.
All right.
I understand what you're saying and I appreciate your time.
Absolutely. All right. Well, anything from the people?
Your Honor, just to clarify, when we do set for a motions hearing, is the court going to be retroactively hearing some of the motions that Mr. Crown already filed?
Yes.
Okay.
Well, I'm assuming, and I actually said this before in an order, or maybe I said it on Monday. I think I told Mr. Crown if the trial gets continued, the court will hear those motions. And I'm talking specifically about the Franks issue.
Suppress.
And you had a motion to suppress?
There was the big ones were the Franks and the suppress.
Okay.
And I think there was a jurisdictional motion that Your Honor said was untimely. And
well, the jurisdictional motion, I'm not going to consider again. I've considered that 3 times. The Supreme Court considered it and didn't take it up. So that's not going to be reheard. But I'm interested in hearing the Franks motion, the suppression motion. I'll hear if you want me to reconsider the amendment, I'll do that. I'm telling you, it's very unlikely that the court will change its ruling on that issue. So those are the things that the court will reconsider.
About the jurisdiction, Your Honor, even if there's cases from the Supreme Court and such as say subject matter
I've already
jurisdiction-
considered that motion. As I said, you filed the motion, you filed a motion to reconsider, you filed a third motion to reconsider, and you Rule 21 that issue. Rule 21 means you filed a motion with the Supreme Court because you didn't agree with the trial court, which is absolutely your right, but the Supreme Court didn't agree with you either at that point. It's possible on appeal that could change, but the Rule 21 answered the issue. So we're done with that issue.
Even though the Supreme Court says you can raise it at any time? It's just done.
Mr. Crown,
I got it.
The trial court is done with that issue.
I hear you.
Okay.
I've got it.
All right. Anything else? Ms., let me just ask, it looks like Ms. Norwood is lead, at least right now. Do you understand what the court might be taking up?
Yes, I do.
Okay. And we will be setting a hearing. Mr. Clark.
Sorry, Your Honor, I was
Your hand motioning like.
I was counting out loud, just to be clear, so
Okay.
we should be prepared for the Franks motion, the motion to suppress motion, any new motions that are filed.
The court will, so any new motions that are filed, the court will issue orders as to whether or not they'll be considered. All right. I'm going to issue an order today with regard to what motions the court is going to reconsider. All right. So typically, I would say, file something that tells me what you want reconsidered. You just put on the record the Franks motion, the suppression motion, the amendments of the counts. Those are things the court is going to reconsider, but I'll put it in an order to make it uber clear. And if there are new motions filed, the court will consider whether or not they will be heard on that new motions hearing. I'm not going to promise that. I'm just going to say, if I think that they warrant being heard after hearing the people's response, the court may hear them at that motions hearing. All right?
Yes, ma'am.
I think that was going to be the people's request, just so we could have a clear distinction.
Absolutely.
Given the amount of filings in this case, and people do appreciate that.
Totally fair. All right. Anything else for today?
I just wanted to put on the record, Your Honor, that I have confirmed that Mr. Crown has the full raw data from his cell phone as well as the Razer laptop. What I'm still figuring out is whether the text messages that he wanted in the entirety are present in any of the reports that have been interpreted by any of the experts, but he does have all the raw data.
Okay.
But as I mentioned in some of the documents that you have before you from today, the zip file, which contains the raw data containing those messages, is corrupted and cannot be opened on a Windows machine. And I'm working hard to get into it with other means, like powerful software.
Well, hold on.
Like that. But
so the zip file that people provided is corrupted?
It says it's corrupted or it can't be opened on a Windows machine. I've tried a couple of other software. I've tried some things and I'm still working on it. And as I said in the response, which is before Your Honor from today, I'm doing my best, and it may require further motions to compel. But the thing is, this Angel Portillo, who did the HSI tag Duluth file that they had originally told me was raw data, but it's not.
Right.
He claims that he did get those messages. but he only reported on the ones that he liked, and he commented on them and highlighted them and truncated. And so it's a summary. And basically the messages that I want that are good for me, it's just like the telephone calls. The one telephone call that came out was, was tame, for the prosecution. But the ones that I want, they had a glitch with the phone. They just couldn't record. They don't have that one, So it's like that kind of thing I feel I'm running into. And that's where I'm headed on this. I haven't heard from Ms. Norwood about that yet. I'm just saying that it's the same kind of thing. There's a cherry picking going on.
Or that's what it appears to be to you.
Well, it's the information.
I haven't seen it, so I don't know.
Right. In the motion to compel, there's the exact window of messages, the amount of messages there are, the amount that appear in the report. There's a gap. Okay.
Right. Okay.
I wouldn't.
So what I'm going to order, Mr. Crown, I'm going to order that you all need to confirm.
Oh, I haven't started yet. We've got 6 more hours.
Because what's being missed, I think, in the motions is you allege these things are missing. And with this type of evidence and discovery, I think you all need to have a conversation with each other, not in motions, but with each other. So everybody's very clear what you're looking for, right? I think you have a better understanding, at least based on your motions, about this type of evidence than the court, but maybe the people as well. So if you can just have the conversation with Ms. Norwood while they're trying to access this information, that's what I'm going to order.
Anytime. And it's all in the motion to compel too.
Okay.
So I made it
pretty
clear.
I thought it would
to speak to them anytime.
All right.
Anytime. They just call me and I'll be there.
Okay. That sounds good. All right. That sounds good. I had another question that came up, but I can't think of it now. Yeah, is Joanne, does she have dates? We can set the hearing right now. Okay. Let's do 2 hours. All right, we have September 8th at 9 or 1:30. We also have September 9th at 1:30 or September 10th at 9.
September 9th at 1:30 and?
Great, thank you. September 10th at 9 or September 8th at 9 or 1:30.
People can accept any of these.
All right, hold on. Okay, so the people can accept any, and yourself?
I as far as I know, I'll just be there whenever you say I have to be there. I don't have a particular preference.
All right, let's set it for September 10th at 9. And I think we'll set for half day just to be very safe. Unless that doesn't work. Hold on, I told Joanne 2 hours. Okay, that does work. So we'll set it so it'll go till the lunch hour. All right?
Your Honor, will I have to subpoena Beverly Allenson, the police officer?
I can't tell you how to proceed on the motion. That's legal advice, unfortunately.
I see.
All right, we're in recess on that case. Oh,
Quickly, Your Honor,
Yes.
filing deadline.
let's have motions filed by no later than, let me just take a look at the calendar real quick. Great question, Ms. Norwood. All right, motions filed no later than September 3rd.
Yes, Judge.
Would you want a refiling of the Franks and suppression motion or just simply?
No, I'm clear on those, so that's fine. If you have motion.
So I'll just do a motion for hearing? Is that how you want? Procedure?
Actually, you don't even need to do that.
We've already taken care of that.
I've already said it, so you don't need to do that. That'll be the order of the court. You'll get the order with regard to this hearing soon. I won't say when because, again, I'm in another trial until it's done, whenever that is. All right. Anything further?
Nothing from the people.
Mr. Crown.
I could probably think of things, but I don't think you want to hear it right now.
Oh, I have until 1 o'clock to hear whatever you need, but.
Well, we handled the,
Nobody ever wants to hear from you about anything.
we handled everything.
Okay.
The motions from today, the multiplicity. There was the proffer agreement thing. I don't know.
I saw the response, so we can put that on the list.
Oh, okay. I just didn't know if it had been disposed of yet, or if there was I didn't see an order on it.
Nope, no order yet.
Okay, so that's out there.
Yep.
So that's going to go on the September 10th day. Is that how you want to handle that?
Unless I think I can rule on it.
Unless you rule on it otherwise.
Right.
Okay.
Exactly.
But it's still pending, and just wanted to double check on that. And there was a motion in limine about the Korean language, but that's also in the Frank's motion, and so Your Honor had ruled that it was untimely, it required more foundation, things like that.
If you want to file more with regard to that, there's the issue with regard to the motion in limine is a little bit different. But that said, if you want to file something more, we'll take them up at the hearing.
Okay, I'll tidy it up with Your Honor's permission. I'll combine there were like 4 separate documents, this various statements and all, because I was in a panic to get everything done. I can combine it all into one motion in limine with the exhibits right attached and make it easier for everybody, if Your Honor will say that's okay to do.
Yeah, just if you do that, tell me in that motion what what motions you're including in that one to make that very clear to the people. Does that make sense?
I'll have a preface statement on there explaining what it is and why it is and how it's, just for the convenience of all concerned and to be handled when the court states that it will be handled.
That sounds good.
Something like that, just because all the statements and the documents could go all together, and I think it would be neater and tidier.
I like that.
I do too. I like things organized. And
all right.
I'm sure you do too.
What else? Anything else?
Nothing from the people.
I hate to say no, but I guess it's time to go. There is the expert witness thing. This is pending also. I'm not making it up. I'm not trying to, waste time. Okay. I didn't even ask for a witness really with the Korean translator. I just want to show in whether it's impeachment or
I've got the video here. There's only a couple minutes left.
or however I do it, that there's a real certified translator who's, agreeing with me that this Korean string isn't Korean and doesn't say apology. But the people were very adamant that I had said there was that I had put a witness on the list and it was untimely and it was too late and all that. And I was like, okay, whatever. All right. I heard and the court ordered on that. Well, now I got a notice attached to with one of the motions from Mr. Sherman the other day. I think there were 3 motions, and there's a I think it's a motion and like a notice of untimely adding of a witness, Mr. Angel Portillo, or Senor Angel Portillo. It was probably how he likes it, but we'll just call him Angel Portillo or Angel Portillo. He wasn't on the witness list. He wasn't on the expert list. And I guess the people, I'm only blaming it on Mr. Sherman because this particular email came right from him. And he wants this guy, this man, Angel Portillo, who is a certified forensic analyst. You can
file a response.
Okay. And I just wondered, if I'm not
So far, he's been a complete douchebag in 4 languages.
allowed to do it, are they allowed to do it?
I can't tell you.
You can't tell.
I can't guide you around the legality
I understand
of what the people are doing and what you're doing. I can only respond.
Okay.
I think I told you on Monday that you're going to have to be able to lay a foundation to admit documents regardless of whether you have a witness or not. And that's the bulk of what I can tell you.
Well, I heard you. I mean, do I know what that actually means? You know, not
Well,
really,
that's-
but I mean, that's my problem. I mean,
That's the issue with proceeding pro se.
got it.
In Your Honor, may I just add that now that the trial's been continued,
No, he was-
Mr. Crown can endorse properly his Korean language expert.
Okay. Thank you for that, Mr. Sherman. I apologize. I did not even see you there.
Sorry.
I never even knew you were there. So you scared us.
Just creeping on you guys.
It's all right.
But
okay.
As far as their late, it says something like late endorsement or whatever. Is it now no longer late? What's late? I mean,
That was a gift from Mr. Sherman to you. I am not allowed to give you legal advice. He just gave you legal advice with regard to whether or not you could file an endorsement of a witness.
He did.
That's as much as I can tell you, Mr. Crown.
I mean, he
And
does
it's-
want to put me in prison for the rest of my life, but he's not a bad guy. He's just doing his job. I know how it is.
Mr. Crown, enough.
You know, I know.
All right. We're done for today. Anything else that you want me to consider, file it.
Yes, ma'am.
All right. We're in recess.
Yes, ma'am.
The holes. This creature, it's like a rodent. It's like nesting underneath my bedroom, like my bedroom floor. The skirting was never fully pulled back when he promised me that. We both saw this creature, and he set traps that were too small. And then he put poison outside the unit. He never pulled the skirting back to put poison on its nest. There are multiple entries around this unit. Please, let me continue. I'm really sorry for wasting your time. We really shouldn't be here.
Ma'am,
So the skirting.
sir, you're not wasting my time. I'm getting paid.
Yes.
Go ahead.
Yes, sir. Well, I'm unemployed. I lost my job like a few weeks.
Okay, go ahead with your. Go ahead.
I know. I'm
Go
sorry.
ahead with your reading, please.
So the traps are too small. And Mr. Weasel, that's the name. That's the person trying to evict me right now. It's Mr. Weasel. Mr. Weasel and I both saw this rodent or creature, not at the same time, but it entered out of the lake. My rental unit is up against a small wooded line about 15 to 20 yards, and then there's a massive lake. So we've both seen this creature. It is fat. It is large. It's like a gopher. It's like a beaver rodent creature. So there's 10 points. There's 10 points. Almost done.
David Morris on behalf of Pleasant Lake Park LLC. Your name, sir?
Christopher Genoviak.
Genoviak. Okay.
You don't use a V.
Got it. All right.
I apologize if I exited last encounter. I just a little bit of pain. It's my first time in court. I wasn't just wanted to get out of the Thunderdome. So, Mr. Allen, good to see you again, Mr. Allen.
This is the Thunderdome?
It's Friday night. I'm in a mood. Definitely don't call me to bail you out, dude. I'm just not feeling it. I'm telling you straight. Oh, wait. Is this case great? I think I know this guy. He's back again. This is gonna be good times, my friend. Your Honor, I apologize for how I fled the scene. I just had to get out of the Thunderdome, if you know what I mean. I was in a little pain my first time in the court, but I'm back with my complaint of a very special sort. There's an infestation, Judge. It's truly hard to bear. There's a critter in my trailer and it's living under there. Is it a mole? Is it a rat? He just doesn't know, but it's bigger than a cat. Mike says, is this the guy? The beaver mole guy. He was crazy the first time. Oh my. A beaver infestation is no laughing matter, but this whole dang story just gets madder and madder. The court sent an inspector to check the holes and poop, but he was hired by Mr. Weasel and I'm in a feedback loop. He's my next door neighbor. He's not insured at all. He owns another trailer park. He really has the gall. It's a major conflict of interest. It's totally absurd. He's the burglar investigating himself. Take my word. Oh my God, Mike just can't breathe. A landlord inspector hired by Mr. Weasel. You won't believe. It's a good thing I didn't start cocktailing before this one. The beaver mole guy is just way too much fun. The judge says, where's the escrow? The rent for November. He says, oh, I just forgot. I didn't remember, but I got it. Don't worry, money is secure. But the inspector's report is clearly perjury for sure. I was not prepared for this denial of reality. I'm talking points point number 17 specifically. Is it a mole? Is it a rat? He just doesn't know, but it's bigger than a cat. Mike says, is this the guy? The beaver mole guy. He was crazy the first time. Oh my, oh my. A beaver infestation is no laughing matter, but this whole dang story just gets madder and madder. The judge said, hold on, son. I'm getting quite confused. We were talking giant beavers, now I feel a bit abused. He says, my trailer's closest to the wood line and the lake. That's where the big beaver-like thing gave me a shake. But the skirting's done. So now I know the deal. The baseboards are ground zero. That's what's real.
This is one of my favorite cases. I'll say it before it's over. I might have to make a song about this beaver-loving rover. So, y'all behave yourself. Stay out of trouble. Don't get hurt. And for the love of God, don't call me. I'm on alert. Just take a damn Uber and leave me all alone with Mr. Weasel and the beaver from the Thunderdome.